Good morning, everybody. Here we go. Birthright citizenship. Let's kill it. Oh, look, we don't know that we're going to know by the end of the day today as far as knowing whether or not this thing will survive. But we should have a really good inkling. And I'll try and help you get a feel for that based on the nature of the questions that we get from Supreme Court, which has not begun its session yet. I've got my camera locked and loaded on it here. But this case is a case that you and I and everyone has been waiting for a long time. Oh, a long time. Pretty much since the day he started this, he came forward with this EO, which was very early. It might have been day one of his administration. They decided to end birthright citizenship. I'll pull up the camera here so you all can be confident that this is that we are live and that we're not missing anything. There it is right there. I'm not sure if you have audio. You guys hear the music in the background? There's like almost like Hispanic music. Trump is on his way. That's what they said. He said he was going to go. People weren't sure if they should believe him. They were like, really? He said that once or twice before. This will be the first time in history a president's sitting in on it. It's hard to say what kind of impact that would have. It's very hard to know. It's very tricky to know exactly what kind of impact that is likely to have. You can hear? Let me remove. Let me do it again. I wasn't sure if I had pulled it out. Who's handsome? Going, let's go! Teachers, I had always said you have only one. You have to have one American citizen parent to be an American citizen. Just hope SCOTUS sees it that way. We need a mic check. Oh, this is getting good. Okay. It sounds like the voice I use for the my lawyer from the Diddy remake. Yeah. Which no one guessed who it was. No one guessed. No. Oh, this is exciting. Very, very exciting. Ooh. Let's see what. Grok, can you tell me, what do you think? Who's going to win on the birthright citizenship case? Do you think Trump's going to win? Or do you think he's going to get knocked out?
Bachelor or Trump?
What? What? I was saying birthright citizenship. Do you think birthright citizenship is going to stand up when it goes to the Supreme Court today? That they're going to decide in favor or are they going to decide against? Oh, there we go. Don't time for you. Oh, yeah. Oh, yeah. I don't hear it either. It's not you. I don't hear it either. How can SCOTUS override a law? They're supposed to follow law. Am I missing something? They're interpreting what the law is.
We will hear argument this morning in case 25-365.
It's a good question. I will answer it.
General Sauer.
Mr. Chief Justice, and may it please the court. The Citizenship Clause was adopted just after the Civil War to grant citizenship to the newly freed slaves and their children, whose allegiance to the United States had been established by generations of domicile here.
I don't like this.
It did not grant citizenship to the children of temporary visitors or illegal aliens who have no such allegiance. This conclusion reflects the original public meaning of the clause. When Congress used the term "not subject to any foreign power" in the Civil Rights Act of 1866, it rejected the British conception of allegiance. Senator Trumbull explained that subject to the jurisdiction thereof, and
I'm switching feeds over to a better feed, which has a better audio, because this was terrible. I'm on Forbes instead.
allegiance. The clause thus does not extend citizenship to the children of temporary visa holders or illegal aliens. Unlike the newly freed slaves, those visitors lack direct and immediate allegiance to the United States.
Yep.
For aliens, lawful domicile is the status that creates the requisite allegiance, and the text of the clause presupposes domicile. For decades following the clause's adoption, commentators recognize that the children of temporary visitors are not citizens, and illegal aliens lack the legal capacity to establish domicile here.
This is true.
Unrestricted birthright citizenship contradicts the practice of the overwhelming majority of modern nations. It demeans the priceless and profound gift of American citizenship. It operates as a powerful pull factor for illegal immigration and rewards illegal aliens who not only violate the immigration laws, but also jump in front of those who follow the rules. It has spawned a sprawling industry of birth tourism, as uncounted thousands of foreigners from potentially hostile nations have flocked to give birth in the United States in recent decades, creating a whole generation of American citizens abroad with no meaningful ties to the United States. I welcome the court's questions.
General Sauer, before we get into the broader national issues, would you start with Dred Scott? Dred Scott was a case about state citizenship. It was a diversity case. And of course, we know what Chief Justice Taney did with that.
Disaster.
How does
Worst case
the
in history.
citizenship clause respond specifically to Dred Scott and answers or changes or corrects its answer as to citizenship? The other point is the citizenship clause refers not just to national citizenship, but also to state citizenship. Are we to have two different definitions for those? It's one word, citizens of the United States and citizens of the state wherein they reside.
That's
So as
interesting
you
question.
begin, I'd like you to go back at the beginning and be more specific about the answer. And I want you to explain whether or not those two definitions are the same or related, and what state citizenship is based on.
Thank you, Justice Thomas. I'll maybe
It's a
start by addressing
subset.
Dred Scott. As you alluded to the fact, Dred Scott, imposed one of the worst injustices in the history of this court, and it led to the outbreak of the Civil War. It's very clear, and this court in all of its early cases interpreting the 14th Amendment said, the one pervading purpose, the main object of the citizenship clause is to overrule Dred Scott and establish the citizenship of the freed slaves. And if you look at the debates in the congressional record and discussion surrounding the adoption of the citizenship clause, what you see is a very clear understanding that the newly freed slaves and their children have a relationship of domicile. They do not have a relationship to any foreign power. For example, there's a comment where he says, look, people have been here for 5 generations and clearly have no relationships to any foreign African potentate, or have a relationship of allegiance to the United States. And that reinforces our point that allegiance is what the word jurisdiction means. It doesn't mean regulatory jurisdiction or sort of being merely subject to the laws. They're talking and they're thinking about it in those debates about allegiance. Now, as to your second question, if you look at the text of the clause.
And his point here is that if you have allegiance to a different power, they can call you to the draft. They can demand you pay taxes. In that case, you're not subject to the jurisdiction. Those are the key words in the amendment, that they have to be subject to the jurisdiction of the United States. If they're subject to a different jurisdiction, they're not subject to the United States, in contrast from the freed slaves who had no other entity that they were subject to. So that's where they're drawing that distinction. That's why that word is implying that it's just for people who don't have allegiance, like the freed slaves, which is what the objective of the amendment was. When he brought up Dred Scott here, which was a terrible decision, that was designed to set John Sauer up, the attorney who's arguing on behalf of the United States, a veteran of Supreme Court oral argument. It was to set him up in order to help contrast slaves who are supposed to be protected by the 14th Amendment with birthright citizenship with people who are citizens of other countries.
Laws, we believe there, it says, born in the United States, born or naturalized in the United States and subject to the jurisdiction thereof, are citizens of the United States and the states of which they reside. So there's a constitutional guarantee that applies to both federal or national and state citizenship. And the key point we make there is that that word reside, if you look at, for example, section 1473 of Justice Story's commentaries, was understood to mean domicile. So when they say subject to the jurisdiction, and then they go on to say you're a citizen of the United States and the state in which they reside, the very text of the clause itself presupposes that the citizen is domiciled in the United States.
The difference between residence and domicile is, and this is something lawyers know, most lay people would not know, you can have multiple residences. You can have houses in Florida and Nebraska and all these other, that's a residence. That's where you reside. Domicile is you only have one. That's your king. This is where my domicile is. And that's what they're saying is when they use reside back then, they use that the way we use domicile today.
In a state at all, they reside there. Reside means domicile.
It's an originalist. It's actually
and we think that
textualist
strongly supports
argument.
our interpretation. It's textual evidence of our domicile-based theory of jurisdiction.
See?
Well, starting with that theory,
It's John Roberts
you obviously
talking
put a
about
lot of weight on subject to the jurisdiction thereof. But the examples you give to support that strike me as very quirky. Children of ambassadors.
That's not a good
Children
sign.
of enemies during a hostile invasion. Children on warships.
That's not a good
And
sign.
then you expand it to the whole class of illegal aliens are here in the country. I'm not quite sure how you can get to that big group from such tiny and sort of idiosyncratic examples.
There are those sort of narrow exceptions for ambassador foreign public ships. Tribal lineage is an enormous one that they were very focused on in the debates as well. But what I do is I invite the court to look at the intervening step, which is the enactment of the Civil Rights Act of 1866. And there they didn't say subject to the jurisdiction thereof. There it says not subject to any foreign power. Now, if you go back to Blackstone and Calvin's case, they say it does not matter if you are subject to any foreign power. If you are born in the king's domains, you have this indefeasible duty of allegiance to the king at any time. So there's a clear repudiation in the Civil Rights Act. The Civil Rights Act is this breakwater, which makes it very, very clear that they are not thinking about allegiance in the terms of like the British common law. They've adopted the Republican conception of allegiance. So it's from not subject to any foreign power. And then the debates just a couple months later make it very clear that they're recodifying the same conception. They were dissatisfied with the potential ambiguity in the phrase Indians not taxed, and they adopted subject to the jurisdiction thereof. And
But to be clear, this is civil rights movement of the 1860s, not of the 1960s. It seems like the 60s is a good time for civil rights movements.
the strongest statements of this is Senator Trumbull's statement that I quoted at the beginning, where he says, he's asked, what does that mean, subject to the jurisdiction thereof? And he says, it means not owing allegiance to anybody else. That is what it means. And this court picked up on that in Elk against Wilkins when it says, it uses, completely subject to the political jurisdiction, not mere regulatory jurisdiction.
What do you do with Wong Kim Ark's quote of Daniel Webster, who said, independently of a residence,
Sotomayor.
with intention to continue such residence, independently of any domiciliation, independently of the taking of any oath of allegiance or renouncing any former allegiance, it is well known that by the public law, a non-citizen, while he is here in the United States, owes obedience to this country's laws. Now, the examples that Wong Ark Kim used as exceptions are situations in which there was not temporary allegiance to the United States. The children of foreign diplomats whose only allegiance was to their foreign country, and or occupied territory residents, including those citizens in Maine who had been occupied by the British forces. The US had no control over them. And the whole theory of the Indian tribes was similar. The Indian tribes were analogized to foreign diplomats. So what do we do with that?
I'd say two things. First, as the Indian tribes, we think that's a case that strongly supports us because, of course, by 1866 and 1868, there was strong understanding that the Indian tribes were subject to the United States' regulatory jurisdiction.
But not the same way that temporary foreigners were, meaning there was a real debate going on whether the U.S. actually had jurisdiction over Indian tribes. That's why our cases,
Back in the 1860s, there was a class of people who were known as temporary, as temporary, as like a permanent status of being temporary resident. Like they're permanent residents, but you're not citizens.
for the longest time, until that was finally settled, said, absent some act of Congress, our laws don't apply. U.S. laws don't apply to Indians on Indian lands, correct?
I believe you look at the Rogers decision, for example, that we cite in our brief, where they say that they are subject to the United
That's
States
later. I'm
regulatory
talking at the time.
Yes, at the time. So as to
All right, so
1817.
what do you do during the debates of the 1866 Civil Rights Act and of the 14th Amendment, with the entire discussion of the people who opposed the amendment, who kept saying, we can't pass it because we're making citizens of gypsies
Correct.
who have no allegiance to anybody, and we're going to make citizens of Chinese people who can't be citizens because we're not going to permit them to be citizens.
There was a law against
What do
that.
we do with those debates and the fact that the proponents of both acts said everyone who's born in the U.S. will be citizens?
First, as to that particular exchange, page 2890 of the congressional record from 1866, Senator Cowan gives this virulently racist statement where he says that. And what does he say right?
And she seems to be purposefully bringing up, the racist perspectives of the past and saying you want to rely on those racist perspectives. And this is a tricky area for him to walk.
At the beginning of that sort of offensive speech, he says we can't have children of gypsies, children of Chinese immigrants. We can't have them become citizens. And he says, quote, have they any more rights than a sojourner in the United States? So he's trying to persuade the Republicans to his view by appealing to a common understanding that sojourners do not have children who become citizens. So there's powerful evidence there that everybody understood this to, not sweep in the temporary sojourner. And that's why you see for 40, 50 years, you see every commentator who addresses the specific question of temporary presence saying it's not covered by the clause, including for decades after Wong Kim Ark.
General, can I take you back to the Chief Justice's question about the specific exceptions to birthright citizenship that everybody seems to agree were recognized under the common law? And it brings up an important principle about how we interpret the law. When particular problems pop up, lawmakers may enact a general rule. When they do that, is the application of that general rule limited only to the situations that they had in mind when they adopted the general rule? Or do we say they adopted a general rule, they meant for that to apply to later applications that might come up? Justice Scalia had an example that dealt with this situation. He imagined an old theft statute that was enacted well before anybody conceived of a microwave oven, and then afterwards someone is charged with the crime of stealing a microwave oven, and this fellow says, well, I can't be convicted under this because the microwave oven didn't exist at that time. And he dismissed that. There's a general rule there, and you apply it to future applications. And what we're dealing with here is something that was basically unknown at the time when the 14th Amendment was adopted, which is illegal immigration. So how do we deal with that situation when we have a general rule?
Yeah, I strongly agree with the way that you framed it, that there is a general principle, that's a broad principle that's adopted in the phrase subject to the jurisdiction thereof. And we submit that our theory of allegiance and domicile-based allegiance is what explains those specific exceptions that everybody was aware of, but it is broad enough to sweep in future situations. And as you pointed out, illegal immigration did not exist then. Now, the problem of temporary visitors did exist. And it's very interesting that as you look at pages 26 and 28 of our brief, commentators going from 1881 until 1922 are uniformly saying the children of temporary visitors are not included. Now that logic, we say, it naturally extends. It's really an a fortiori case. If you have someone who enters illegally by the 1880s, there are restrictions on immigration. If you've entered illegally, it's kind of, a well-established principle of law going back to the Code of Justinian that says you're not allowed to be there. You don't have the legal capacity to create domicile there.
But I think, General Sauer, that what you just said suggests that you can't be arguing in the way Justice Alito suggests, because most of your brief is not about illegal aliens. Most of your brief is about people who are just temporarily in the country, where there was quite clearly an experience of, an understanding of, that there were going to be temporary inhabitants. And your whole theory of the case is built on that group. You don't get to talking about undocumented persons until quite later, and at much lesser, I think it's like 10 pages to 3 pages or something like that. So you can't really be going with Justice Alito's theory. You must be saying that there's a principle that developed, that was there in at the time of the 14th Amendment. Isn't that right?
We agree there's a principle there at the 14th Amendment. It is jurisdiction means allegiance, the allegiance of and this very strongly reflected in the 19th century sources, the allegiance of an alien present in another country is determined by domicile. And that goes back to the Venus and the Pizarro. It goes through the Katza affair in 1853. It comes right up to Fong Yui Ting and Lau Al Bu that are decided shortly before Wong Kim Ark. So that's the principle. That principle clearly applies here. I also respectfully disagree.
Yeah, and I guess, Mr. General Sauer, where does this principle come from? Allegiance, domicile, allegiance, I think you point to a Lincoln funeral speech as your primary example of where this principle comes from. It's certainly not what we think of when we think of the word jurisdiction, and I appreciate that jurisdiction has many meanings, but the first meaning is like, if you're subject to jurisdiction, you're subject to the authority of. One doesn't say, oh, what that means is a certain kind of allegiance that domiciliaries have and nobody else does. So the text of the clause, I think, does not support you. I think you're sort of looking for some more technical, esoteric meaning. And then the question comes, okay, if the text doesn't support you, if there's a real history of people using it that way, but as far as I can tell, at the time of the 14th, you're using some pretty obscure sources to get to this concept.
Well, I take it straight from the framers' mouths. So, for example, Senator Trumbull was asked, what does jurisdiction mean? He means subject to the jurisdiction. He said, what does that mean? He says it means not owing allegiance to anybody else. He is the principal.
You're twisting what jurisdiction means to today's
Bigham, who's the framer of the 14th Amendment, is asked, what does it mean in the congressional record at page 1291? He says, within the jurisdiction of the United States of parents not owing allegiance to any foreign sovereignty. And we've cited
I'm not twisting it, you are.
Where the congressional debates reflect that. Then you referred to the oration of George Bancroft. That's one of probably 16 sources, but there's at least 13, counting that one in the 12 treatises we cited, pages 26 to 28 of our brief. There is over a dozen sources that specifically address temporary sojourners. In the 5 decades after the enactment of the amendment, every single one of them says, well, temporary sojourners, their children are not included, including for 2 decades after Wong Kim Ark.
So if domicile's the key linchpin to your argument, and I take it that it is, do we look at how domicile was understood in 1868? Or do we look at it how it's understood today in context of the INA?
The 1868 understanding, I'm not aware of a strong difference between those.
Well, here's where I'm going with it. I'm just working within your argument for a moment. Today, you can point to laws against immigration that are much more restrictive than they were in 1860. We really didn't have laws like that we do today until maybe 1880. So if somebody showed up here in 1868 and established domicile, that was perfectly fine without respect to anything, any immigration laws. There they were. And so why wouldn't we, even if we were to apply your own test, come to the conclusion that the fact that someone might be illegal is immaterial?
I would first cite Wong Kim Ark on that point, because Wong Kim Ark says
Well, I'm not sure how much you want to rely on Wong Kim Ark.
But there is a statement in there that says, so long as they are permitted to be here. So Wong Kim Ark, keep in mind that by the time they decide Wong Kim Ark in 1898.
But that's 1898. Now I'm looking at 1868. You're telling me is when I should look, and the test for domicile. And the stuff you have about unlawfully present is like Roman law sources you're going to.
First and second restatements as well, and decisions of this court.
So it wouldn't be the INA that would control whether you're capable of having domicile. It would be whatever the law was in 1868.
I think that this is addressed by my exchange with Justice Alito from earlier, which is that this concept, jurisdiction, baking in allegiance and domicile is
Congress
applied
could
to.
continually restrict who may lawfully be present
Ms.
more
Gorsuch.
and more, and you'd say that would be incorporated into it, even though you're telling us to apply the original meaning of 1868.
The original meaning of domicile.
That's not
And
good.
so the question is there any argument that the framers intended to preclude Congress from dictating who can and who cannot establish a lawful domicile here? I don't see any evidence of that in the congressional record, so it's a natural extension.
Whose domicile matters? I mean, it's not the child, obviously. It's the parents you'd have us focus on. And, what if, is it the husband? Is it the wife? What if they're unmarried? Whose domicile?
Well, in the executive order, it draws a distinction between the mother and the father. It's really the mother's domicile. I think that would matter.
Well,
there,
but
because that's the
1868 matters, you're telling us. So what's the answer?
The 1868 sources talk about parental. I'm not aware of them drawing a distinction between mother or father, but they say the domicile of the child follows the domicile of the parents.
And how are we going to determine domicile? I mean, would we use contemporary sources on what qualifies as domicile in a state, or do we look in 1868?
It's not looking good.
And do we have to do this for every single person?
This is
Again, I don't
Gorsuch.
see a strong distinction between those because, of course, domicile is a high-level concept, has been pretty consistent over centuries, which is lawful presence with the intent to remain permanently. That domicile, when you come to a new nation, you say, I'm here to stay, you become part of their political community, and you become akin to a citizen. And that's reflected very strongly in the case I cited before.
And just to circle back to Justice Kagan's point, it's striking that in none of the debates do we have parents discussed. We have the child's citizenship and the focus of clauses on the child, not on the parents. And you don't see domicile mentioned in the debates. That's the absence is striking.
I think the 19th century sources would say a newborn child lacks the capacity to form a domicile, so they're imputed the domicile of their parents. So I don't think they would have seen a distinction between children and parents. And I point out that their position, like ours, is
Justices are taking a 21st century perspective to text that was drafted in the 19th century, which is stupid. Back then, they're not worrying about single mothers. That's not like what the framers are likely fixating on, or single parents and whose domicile and whatever. It's pretty ridiculous to try and say that's a textualist position. And by saying that, it's striking. This is not looking good for us, though, so far. But we need to see how the questions go against the other side. Sometimes they're hard on both sides.
forced to look at the domicile of the parents because we look at the exceptions that they accept, like
I'm talking about
tribal Indians and so forth.
I'm talking about in the debates over the 14th Amendment and the Civil Rights Act. It's striking that these concepts aren't discussed in them.
I think domicile is discussed. I mean, it's brought up in many.
Allegiance, jurisdiction, complete jurisdiction.
Well, I mean, here's just a few examples. Page 1679 of the congressional record, President Johnson vetoes the first version of the Civil Rights Act, and he says, I can't sign this because it would extend citizenship to the children of, quote, all domiciled aliens and foreigners, even if not naturalized. And you have all the other sources we cited that say, this is a deeply rooted 19th century understanding. It's reflected in the Venus. It's reflected in the Pizarro in 1814 and 1817. It carries through the 19th century, and this court is talking about it in 1892 and 1893 when it's discussing the Chinese Exclusion Acts. Domicile is the key concept that creates allegiance. That's
General,
So
you said in your reply brief
It was Barrett,
that
obviously.
the children of slaves who were brought here unlawfully, in defiance of laws forbidding the slave trade, would in fact be citizens. And we can imagine that their parents were not only brought here in violation of United States law, but were here against their will, and so maybe felt allegiance to the countries where they were from. And you say that the purpose of the 14th Amendment was to put all slaves on equal footing, newly freed slaves on equal footing, and so they would be citizens. But that's not textual. So how do you get there? You say it in just a few sentences, so can you elaborate?
Sure. If you look at the 19th century sources, what you see is that even though their entry may have been unlawful, 19th century antebellum law never treated their presence as unlawful. In fact, quite the opposite. One of the amici, in fact, points to like a Mississippi statute, which probably is replicated throughout the South before the Civil War, that says slaves in Mississippi have an indefeasible domicile in Mississippi. In other words, even if they run away, if they get away, Mississippi says, nope, you still live here. right? And so it would be astonishing, in other words, for the opponents of the 14th Amendment to say, oh, you know, these people were not domiciled and therefore it goes the other way, because actually U.S. law, even if they were brought in illegally and you know, through an illegal slave trade, once they were there by
Well, their
domestic law,
intent is to return as soon as they can, let's say. So they're here, they're resident, and maybe under your theory, I mean, which says, well, lawfulness for a different purpose, but they're here, they're resident. Let's take your assumption that they're not here unlawfully. But let's say they don't have an intent to stay. They want to escape and go back the second they can. Are they domiciled?
Under the 19th century law, I mean, I think this is the flip side of the hypothetical that we talked about earlier. Under 19th century law, they are treated as domiciled in the United States. So it'd be astonishing. And in the debates in the congressional floor, talk about not this specific case, but to say, look, slaves who have been forced to come here and have been here are lawfully domiciled here. I mean, they don't use the ways domiciled, but like they use allegiance. They say they don't have allegiance to, once they've been forced to come here, they don't have allegiance to any foreign or African potentate, and therefore
General, that goes
How
to
would that apply to the children of illegally trafficked people today? Would the same reasoning apply?
it would turn on whether the parents are lawfully domiciled in the United States.
So if they're brought in illegally, but then they choose to remain and they want to remain and they're domiciled, you would say that their lawful presence is
No,
not
'cause they don't have a
dictated
right to be
by
here.
whether they were brought here lawfully or not. And that's different from someone who, say, crosses the border unlawfully.
Yeah, I think it would turn on whether their presence is lawful.
General,
In other words, obviously there may be many other important
Jackson
things
needs
that
to
could be
weigh in
done to
with her
assist people
stupidity.
like that. The question is, if they give birth to someone in the United States, that person naturally a citizen, that would turn, based on the original public meaning of the clause, on the lawfulness of their presence. Are they domiciled?
General, can I ask you a question?
Those were very neutral questions from Barrett's, which were surprisingly neutral compared to Gorsuch's take so far.
To follow up on what Justice Gorsuch was exploring with you with respect to domicile, did I understand you to say that domicile is going to be eventually or is controlled by Congress? Who is domiciled? I'm struggling to figure out who is domiciled.
You're struggling
in
to
your
figure out a
argument.
lot.
The domiciliaries are people who are lawfully present and have an intent to remain permanently. So that's a kind of black letter, understanding of domicile.
Basic
Now,
law.
Congress can't dictate that certain classes of people, legal
Let's
entrants
walk
and so
Supreme Court
forth,
justices through
cannot
basic law.
lawfully lack the legal capacity to form a legally binding
Embarrassment.
But
domicile.
if that's so, then doesn't it make the domicile for the purpose of the 14th Amendment turn then ultimately on Congress's will in a way that the framers did not intend? I mean, my understanding was the framers
Why?
put this citizenship clause into the Constitution to prevent future Congresses from being able to affect citizenship in this way.
Sure.
Very briefly, no, I don't think so, because it is up to the alien whether or not they want to be domiciled here. Now, there may be
But I
collateral
thought you just
consequences.
said Congress can make determinations as to who counts as being domiciled here.
Yeah,
So
and
if
this-
that's true, then it ultimately would impact, in your theory, whether or not this person can claim that they have citizenship for 14th Amendment purposes based on Congress's determination. And I just thought that's what the 14th Amendment was trying to get away from.
if I may.
Yes, please.
Very briefly, I just point you to the discussion in Professor Werman's amicus brief, where he talks about this is not a new problem. Going back even to the British common law, there's a situation of people who lack a safe conduct and are passing through the king's domains without permission. And he says the best reading of the common law is they are not under the protection of the king and they're not covered by the rule of birthright citizenship.
Thank you, counsel. You mentioned in your briefing and also this morning the problem of birth tourism. Do you have any information about how common that is or how significant a problem it is?
It's a great question. No one knows for sure. There's a March 9th letter from a number of members of Congress to DHS saying, do we have any information about this? The media reports indicate estimates could be over 1 million or 1.5 million from the People's Republic of China alone. The congressional report that we cite in our brief talks about
a million
certain hotspots
Americans
like Russian elites coming to Miami through these birth tourism companies.
That's Alito asked that question.
Here's a fact about it that I think is striking. Media reported as early as 2015 that based on Chinese media reports, there are 500 birth tourism companies in the People's Republic of China whose business is to bring people here to give birth and return to that nation.
Retarded.
Having said all that, you do agree that that has no impact on the legal analysis before us?
I think it's, I quote what Justice Scalia said in his Hamdan dissent, where their interpretation has these implications that could not possibly have been approved by the 19th century framers of this
They
amendment.
never would have agreed to this. You know they never would have agreed to
made a
this.
mess. Their interpretation has made a mess of the provision.
Well, it certainly wasn't a problem in the 19th century.
No, but of course, we're in a new world now, as Justice Alito pointed out to, where 8 billion people are one plane ride away from having a child who's a U.S. citizen.
Well, it's a new world. It's the same Constitution.
It is, and as Justice Scalia said, I think in the case that Justice Alito was referring to, you've got a constitutional provision that addresses certain evils, and it should be extended to reasonably comparable evils. He said that about statutory interpretation. I think the same principle applies here, and I think we quote that in our brief.
Thank you. Justice Thomas, anything further?
Generally, you're getting a lot of questions about immigration, and they harken back, of course, to the citizenship, which is defined in or set out in the 14th Amendment. How much of the debates around the 14th Amendment had anything to do with immigration?
I think that the principal focus of those debates, it has to do really not with immigrants, but with the Indian tribes. I mean, obviously the main goal, the one pervading purpose, as this court said in the slaughterhouse cases, was to establish the citizenship of the freed slaves and their children. But they were very concerned about the problem of something that they all accepted as a given, which is that the children of tribal Indians are not within the rule of birthright citizenship. So I think that's what they focus on. We draw an analogy to that, to the issue of temporary sojourners. And then, but there are mentions of temporary sojourning multiple places in the congressional debates, and all of those quotes go in our direction.
And there was, Justice Sotomayor brought up Wong Kim Ark. There was no question in that case that about domicile, was there?
I disagree. The court says at the very beginning of its opinion, here are the accepted facts. These are lawfully domiciled here. When it states the question presented, it talks about domicile. When it recites the legal principle at page 693, it says domicile 3 times. And at page 705, at the end of the opinion, it says, here's the single question we've decided. We've decided that Chinese immigrants with a permanent domicile and residence here fall within the rule of birthright citizenship.
Justice Alito?
Under the minimum definition of domicile, which I think existed in 1868 and continues to exist today, a person's domicile is the place where he or she intends to make a permanent home. Now, normally you would think that a person who is subject to arrest at any time and removal could not establish domicile. But we have an unusual situation here because our immigration laws have been ineffectively and in some
This is the Biden
instances
effect.
Unenthusiastically enforced by federal officials. So there are people who are subject to removal at any time if they are apprehended and they go through the proper procedures. But they have, in their minds, made a permanent home here and have established roots. And that raises a humanitarian problem. And I wonder if you could address that.
If I may, one legal and one humanitarian. The legal point is, if you look at those cases, for example, Carson against Reed, Park against Barr, this court's decisions in Elkins and Toll against Marino, they talk about the legal capacity to create a domicile, excluding someone who may have the subjective intent, which otherwise would be determinative, as being excluded. On the humanitarian point, I would point out, as I said at the beginning, Justice Alito, that the United States rule of nearly unrestricted birthright citizenship is an outlier among modern nations. It's a very small minority of nations that have that rule. For example, every nation in Europe has a different rule. And the notion that they have a huge humanitarian crisis as a result of not having unrestricted birthright citizenship, I don't think is a strong argument. And I point out,
Good response. Tough question.
For reliance-related reasons, this executive order applies only prospectively, and we ask the court to rule only prospectively.
Justice Sotomayor?
I agree with you with the European nation's rule is, but England was always different, wasn't it?
So
Not until 1983, it changed to the
That's not quite true.
how much were we part of
The
England in
Wong
1870?
Kim Ark does a wonderful job of laying out the English rule. And you claim it was different, but there isn't any treatises or scholars who say it's different. English rule was always by birth. Other countries were not by birth. Let me just go to the implications of what you're asking us to do. You are asking us to overrule Wong Kim Ark?
No.
Well,
We're consistent with Wong Kim Ark.
Kim Ark's parents were domiciled in the US, but they owed loyalty to China. They eventually returned to China. So they didn't have a primary allegiance to the United States. So you're not asking that. Are you asking us to overrule then our cases, one of which said that a child of illegal aliens was a citizen? You're asking us to overrule that.
No, first of all, we're not asking you over to rule Wong Kim Ark.
Thank
We
you.
But
agree
you
with the
are
holding of
asking
Wong
us
Kim Ark
to-
and much of the reasoning. And then as to those later cases starting in 1966, where the court makes sort of, unreasoned references to this
Wait a
issue,
minute,
we think
thin top you loose. The respondent unlawfully overstayed her visa and gave birth to a child here. The court, Harlan II, wrote, the child is of course an American citizen. That person wasn't domiciled here lawfully. So you're asking us to overrule that case?
I wouldn't say we're asking you to overrule. We think that's similar to a drive-by jurisdictional ruling where there's a simple statement that's not debated. There's no further analysis of it. There's really an assumption there. And we think that's similar to cases where the court just assumes jurisdiction without discussing it.
When we ruled in Trind that Indians could not become citizens, the government then after began to unnaturalize many Indians who had been sworn in as citizens. You asked us to concentrate only on the prospective nature of the citizen's order. But the logic of your position, if accepted, is that this president or the next president or a Congress or someone else could decide that it shouldn't be prospective. There would be nothing
No.
limiting that,
No, because
according to your theory.
you establish
If, as we asked, the court confines its ruling to prospective relief only, which it did in
No, I'm
Sessions
saying
against.
to you, that's what you're asking us for relief right now. I'm asking whether the logic of your theory
how's that relevant?
would
It's
permit
not-
what
not
happened
before the court.
after the court's decision in Trin, that the government could move to unnaturalize
And you can easily
people
say,
who were
no,
born here
you're not allowed to do that.
of illegal residents.
You could write that in your
No, we
ruling.
believe the court should do what it did in Sessions against Morales-Santana, where there was a ruling that would have deprived people who are already citizens of citizenship, and the court said this applies prospectively only, and we think that's the appropriate
Well-
course here.
But that's not what we did in Trin.
We think that Sessions provides the proper course here, and that's what we're asking. We are not asking for any retroactive relief.
Justice Kagan?
General, I think even your brief concedes that the position you're taking now is a revisionist one with respect to a substantial part of our history. And I think that that's in large part because of Wong Kim Ark and the way people have read that case, which of course was in the late 19th century, and have read it ever since then. And what that case suggests is, there's a very clear rationale. You say, oh, it says the word domicile a bunch of times, which it does. It's a long opinion. It says a lot of things. But the rationale of the case is really quite clear. It says there was this common law tradition. It came from England. We know what it was. Everybody got citizenship by birth, except for a few discrete categories, which were the ones that the Chief Justice mentioned at the beginning. And that tradition carried over to the United States. And then what the 14th Amendment did was accept that tradition and not attempt to place any limitations on it. And so that was the clear rationale, a clear
I'm going to come back
rationale
to this. It's
that
not
is
really.
diametrically different from your rationale. And everybody took Wong Kim Ark to say that, and to say that as a result of that, of course, birthright citizenship was the rule. And I think everybody has believed that for a long, long time. And I guess my question is this.
So what?
You have a story
It's
about—
not revisionist just because people have misunderstood what a decision says. That's not revisionist at all. That's ridiculous. It's not like there were further court decisions based on it, which we're looking to change.
what about the reasons why we should go back to what you view as the original meaning. And given the long history of this country's understanding about birthright citizenship, what would it take? What do you think it should take to accept that story in terms of the magnitude of the evidence that we would need to see in order to accept this revisionist theory and in order to change what I think people have thought the rule was for more than a century?
Let me make 2 points in response to that, one historical and one legal. Historical point, I disagree with the way you've characterized the understanding of Wong Kim Ark, and I would point to something that's emphasized in their amici's briefs, which is in 1921, Richard Flournoy, who becomes a senior State Department official in the Roosevelt administration and pushes their theory as to temporary sojourners, writes a law review article in 1921 where he says, I think the children of temporary visitors should be citizens. But he admits that is not the understanding of Wong Kim Ark. He admits Wong Kim Ark did not hold that. And he admits that there's an array of authorities that go against him. He talks about careful and reliable, high authorities. And that's referring to the consensus that we point out in pages 26, 28 of our brief. We've got 12 treatises from 1881 to 1922 that all say, including for decades after Wong Kim Ark, that say children of temporary sojourners are not included. What happens between 1921 and the 1930s? Well, Mr. Flournoy became a senior State Department official, and he adopted that as the policy of the Roosevelt administration.
So you're the revising.
Basically saying there wasn't this consensus going back to 1898.
You're the one engaging
consensus, as their own
revisionism.
author admits, goes entirely in the opposite direction.
Thank
For
you.
50 years, right? For 50 years from the framing of the clause through the 1920s, maybe 60 years, the general understanding when it comes to what's at issue here and was not an issue in Wong Kim Ark is the children of temporary visitors do not become citizens under the clause. And then the legal point, you referred to this sort of concept of temporary local allegiance, and they rely on the Schooner Exchange, this theory that you've got temporary local allegiance. But if you actually look at page 572 of the congressional record, right at the beginning, introducing the Civil Rights Act, Senator Trumbull says, I said not subject to any foreign power. I wanted to say born in the United States and owing allegiance to the United States, but I was aware that there's a, quote, a sort of allegiance from persons temporarily resident in the United States whom we have no right to make citizens. So Senator Trumbull says the reason I haven't adopted the language and meaning that they say should be packed into these provisions is that everybody knows that the children of temporary visitors should not be citizens.
Thank you, General.
Justice Gorsuch?
Just to follow up on that point, General, one interesting counterpoint about the understanding of Wong Kim Ark that followed with respect to temporary sojourners. And I take you've got your well-taken points. But there was, of course, John Marshall Harlan, the great dissenter who dissented in Wong Kim Ark and later gave a bunch of lectures. And he posed the question about the sojourners. Suppose an English father and mother went down to the hot springs to get rid of the gout. And while there, they have a child, now back in England. Is that child a citizen of the United States, born of the jurisdiction thereof by mere accident of birth? And he says, under Wong Kim Ark, he is. And he continues, I was one of the minority, and of course I was wrong. Now, I'm sure that was tongue-in-cheek, but now what do you do with that?
I say two things.
What I do with that is look at Tangi Brown Jackson, and she clearly doesn't understand many of the decisions. So just because he misunderstood the decision when he's dissenting, we have a long tradition of dissenters not actually understanding what the majority is trying to say. So I don't know why you would bring that as evidence.
Response to that. First of all, he gave a speech, but we have 12 uncontradicted treatises that say the opposite, that is not what Wong Kim Ark means, and that's not the meaning of the clause. But also, I make a more fundamental point. When you're looking at Wong Kim Ark, one of the dissent has this dominant theme that really, Tom Thiem, like, you can't be doing this because you can't make and we all agree, or it's obvious, that the children of temporary visitors do not become citizens. And how does the majority opinion address that? It says domicile 3 times when it recites the legal rule. It says permanent residence and domicile when it decides the holding. So the court should be bound by what it says. This is what we're deciding. And again, on page 75, it says this is the single question. Now, there's been a lot of discussion up to that point, but at the very end, they said the single question we've decided is the citizenship status of the children of Chinese immigrants with a permanent residence and domicile in the United States.
Do you think Native Americans today are birthright citizens under your test and under your friend's test?
I think so. I mean, obviously, they've been granted citizenship by statute.
Put aside the statute. Do you think they're birthright citizens?
No, I think the clear understanding that everybody agrees in the congressional debates is that the children of tribal Indians are not birthright citizens.
I understand that's what they said, but your test is the domicile of the parents. And that would be the test you'd have us apply today, right?
Yes, yes. So if a tribal Indian, for example, gives up allegiance to...
Born today, birthright citizens.
I think so on our test. Yeah, if they're lawfully domiciled here.
Okay. And then
I'm not sure. I have to think that through, but
that's
my reaction.
I'll take the yes. That's all right. And then I just want to ask you quickly about the INA adopted in 1940 and 1952. It uses the same term as the Citizenship Clause, and one might have a pretty good argument. I'm sure you got some arguments along just these lines that it should be understood to mean whatever it meant in 1868. But there was a lot of water over the dam between those two things. And as your brief points out, by the Roosevelt administration, there's a pretty strong jus soli move. That is to say that the thin concept of jurisdiction, power over, is enough, a broader understanding of birthright. Would there be an argument for reading that statute under its original plain meaning at the time, 1940, 1952, to perhaps have a different meaning than the Constitution?
We don't think that's the best interpretation. I give 2 reasons. One is it would be very surprising if a statute that says exactly the constitutional phrase subject to the jurisdiction thereof were interpreted to mean something totally different or to ossify a then current misunderstanding of the clause. We think that the best analogy here is probably state long-arm statutes. Take a sort of non-controversial example. State long-arm statutes routinely say we're going to exercise personal jurisdiction to the extent of due process. It takes the constitutional standard and it puts it in the statute. And nobody thinks that those ossify, are limited to the precedent, this court's precedents at the time they were enacted. Everyone thinks that phrase due process incorporates, the developing law of due process and minimum context and so forth, including from this court. So we think that's the best analogy when you're looking at the constitutional phrase itself and you take it out of a freighted context. The natural interpretation is say this reflects the objective meaning of the Constitution, and the objective meaning of the Constitution is its original public meaning in 1866.
Do you see any notable counterpoints to that argument?
I'm sure there are arguments on the other side. We addressed them in their brief.
So you're really, at the end of the day, then, this is a straight up constitutional ruling you want from this court, win, lose, or draw?
Yeah, we think that the statute and the Constitution means the same thing. If the court disagrees, obviously we prefer an adverse ruling. If the court's going to do that on a statutory basis than a constitutional basis.
But you just disavowed that in your responses to me by saying that that's not an available option. That's the way I understood it.
Yes, the court would have to disagree with our statutory position, which is that it means the same thing as the Constitution. But if the court were to do that, then the natural course would probably be to rule on statutory grounds alone. Now, we think they mean the same thing, and we've got arguments for that, including, I think, the analogy I just referenced.
Thank you.
Justice Kavanaugh?
General, how should we think about the text of the 14th Amendment, subject to the jurisdiction thereof, as distinct from the different language of the Civil Rights Act of 1866, which refers, as you know, to persons not subject to any foreign power? Those texts are on their
That's a reasonable
face
question.
Different in the history that Justice Kagan referred to.
That's a reasonable
might have
question.
developed quite a bit differently if the 14th Amendment's text had used the phrase that was in the Civil Rights Act.
That's an excellent point, and this court has held in multiple cases, Heard against Hodge and General Building Contractors, has recognized that they were intended and they did mean the same thing, and that's powerfully reinforced by the congressional debates, where you really what they're discussing is they said they were dissatisfied with the language in the Civil Rights Act because the phrase Indians not taxed they thought was ambiguous. And so they switched to the affirmative statement as opposed to the negative statement. The affirmative statement is subject to the jurisdiction thereof, but there's express statements in the congressional record essentially that we're doing the same thing. And that is what this court's case law has reflected.
Why didn't they say the same thing?
Again, it appears they preferred the sort of positive formulation subject to the jurisdiction thereof as opposed to not subject to any foreign power. And again, there's a deep concern and lengthy discussion of the potential ambiguity in the Civil Rights Act thing. They want to eliminate an ambiguity, but do the same thing. And I think that that's very strongly reflected in those debates.
By the time of the 1940 and 1952 congressional actions, where Congress repeats subject to the jurisdiction thereof, given Wong Kim Ark, one might have expected Congress to use a different phrase if it wanted to try to disagree with Wong Kim Ark on what the scope of birthright citizenship or the scope of citizenship should be. And yet Congress repeats that same language knowing what the interpretation had been. So how are we to think about that?
I think baked into that question is an understanding. I think that was reflected in Justice Kagan's earlier question that everybody understood that Wong Kim Ark meant that, and the history I talked about, I think refutes that really there's a consensus that goes our way for decades and decades after the adoption of the amendment.
This actually helps
Wong
us
Kim Ark on the specific question of the children of temporary visitors. And it's really not until, and again, their author in 1921 is saying, hey, the other side is the consensus.
I'm sorry.
Sorry, go ahead.
But there's
what he's saying there is the fact that when they had later statutes that they didn't change it. You're saying that that's a problem for me. It's only a problem for me if you bake in that was their understanding, like Kagan's saying. But I told you it wasn't their understanding. So then it flips back to being a point in my favor that they were totally fine with the holding of Wong Kim Ark, as I am, because I think Wong Kim Ark supports abolishing birthright citizenship.
Branch interpretations and others. And if you're in Congress in 1940 and 1952 and you want to limit the scope of Wong Kim Ark or to eliminate ambiguity, why do you repeat the same language rather than choosing something different? For example, you could use the language from the Civil Rights Act of 1866 or some similar formulation if your idea in 1940 and 1952 was to not have ambiguity or not have an overly broad scope.
I think if you look at the structure of that statute where it's 1401A and then B through H, A, and it says these are the people who are entitled to birthright citizenship. A is the constitutional standard, and then B through H are all the categories that Congress has super added to that. I think the natural inference is that Congress is codifying, which it was consciously doing in 1941, pulling all the naturalization rules and immigration rules together into one statute and said, you go to one place, here's who is a birthright citizen. A, those who are guaranteed that right by the citizenship clause, and B through H are the ones that Congress has added through its naturalization power. So that inference to me says, A is merely, it's not trying to change or alter the constitutional standard, just saying, hey, the baseline is what the Constitution says, and we codify that, and then we move on to the new categories.
Of what relevance, if any, do you think Section 5 of the 14th Amendment has here that gives Congress the power to enforce the article, the 14th Amendment, by appropriate legislation? Does that give Congress room here, or do you not think so?
I do think that a ruling in our favor would leave room for Congress. I don't think you'd have to rely on Section 5. I think that Congress has its own inherent power to grant citizenship by statute. So if the court were to rule in our favor for the classes of individuals
this is
that
Kavanaugh,
should be covered,
and he
Congress
sounds like he's okay.
How much room do you think Section 5 gives, if any, and it may not be any?
He sounds like he could be okay
Congress
here.
To interpret the phrase subject to the jurisdiction thereof, or to define that. Is that relevant at all?
It's a great question, and I'm thinking about it for the first time. I assume it would be governed by the congruence and proportionality test from this court's case law. How that would apply here, I don't know. And I don't think it's presented because our contention is that the statute means exactly the same thing. If anything is congruent and proportional, it's that. And I think the court held that in the United States against Georgia.
You've mentioned several times the practices of other countries, and that's obviously, as a policy matter, supports what you're arguing here, but obviously we try to interpret American law with American precedent based on American history. That's certainly what I try to do, and I think you try to do. And so why should we be thinking about, even though as a policy matter, I get the point, thinking about, gee, European countries don't have this, or most other countries, many other countries in the world don't have this. Doesn't that, I guess I'm not seeing the relevance as a legal, constitutional, interpretive matter necessarily, although I understand it's a very good point as a policy matter.
Yeah, I largely agree with that, and you can view it as being raised preemptively, defensively. I'm going first, but obviously the other side in there, amici say, make it a prediction, end of the world type predictions, and our point is, it's a very small minority of countries. Almost every country, and certainly all European countries, have a different rule, and the world hasn't ended there.
The other side, last one, the other side relies heavily, of course, on Wong Kim Ark, and you disagree with their interpretation. Oftentimes, when you are dealing with a constitutional precedent like this, you might argue, we disagree with that interpretation, but if you adopt their interpretation or agree with their interpretation of that precedent, you should overrule it. And you haven't made that argument here, and I'm just giving you an opportunity to explain why you haven't.
Because we think it's totally unambiguous in Wong Kim Ark that the holding relates to domiciled aliens. And so we strongly agree with the holding. We think domicile was the touchstone, and we think that's not a coincidence for the reason I maybe speculate a little bit when I was talking to Justice Gorsuch about how the dissent raises this, and then the majority's like, we're putting domicile in there, so we know that the absurd conclusion that they say would come from this isn't there. But also domicile as kind of the sort of relationship that creates this relationship of allegiance that makes you part of a political community if you're an alien from another country. That's deeply rooted in their understanding when they're doing it. They talk about domicile in Yikwo against Hopkins in the 1892 and 1893 cases, and there's this deeply rooted understanding, again, that goes all the way back to the early 19th century. So we think that's a really important conception. So I mean, we disagree with some of the dicta in Wong Kim Ark that we discuss, and we think there's dicta that goes our way that the other side overlooks. And we're not asking the court to overrule dicta. We just say don't follow erroneous dicta and don't apply it to this brand new situation that was not decided in Wong Kim Ark.
This is a very interesting legal strategy that I want to point out to you that Trump's attorneys here and John Sauer is taking. Because what Kavanaugh is doing, and Kavanaugh seems as if like he does sort of like the position. He seems like he's on team abolish birthright citizenship, but he might feel like it's losing. So he's like, well, why wouldn't you try to distinguish and say, even if you disagree, overturn it? And this is a very interesting legal strategy that John Sauer was taking just now, where he's like, I don't want you to overturn it because it's so obviously in our favor. The same way I wouldn't want you to overturn the Dobbs decision if there's some question about, federalizing abortion. I wouldn't want you to overturn Bruin because it's so clearly in our favor. So too is Wong Kim Ark. It's a really powerful way, and it's an interesting legal strategy that I like. I like it a lot.
Thank you.
Justice Barrett?
So General Sauer, I want to zoom out a little bit and think about jus soli and jus sanguinis. So as I understand it, at the time of the 14th Amendment, those were the two dominant approaches. Jus soli, the English common law, roughly following the soil. Jus sanguinis, roughly citizenship following the parents. Now, jus soli was very generous on the soil, the English common law, and so it extended citizenship to those born there who may not have been born of parent citizens. But jus sanguinis, if parents who were citizens and had a child abroad, then that child's citizenship followed the parents. So one thing that's puzzling me about your argument when I think about the ratification of the 14th Amendment, in many ways it would have made sense for them, and you acknowledge the jus sanguinis in citing Vattel. It would have made sense in some ways for them to say, okay, we're going to follow, if they wanted to accomplish what you're saying they wanted to accomplish, you could say, well, we're going to follow jus sanguinis because we're going to make it all ride on parentage. But instead, the 14th Amendment, we're talking about subject to the jurisdiction thereof, but it also says born in the United States. So you have the jus soli kind of point there, but you're saying it narrowed that point by tying it to the citizenship of the parents, at least as to soil. But I take it you're not arguing that United States citizens who have children born abroad would qualify for birthright citizenship. So it's kind of a narrower view of both the traditional jus soli rule and a narrower view of the jus sanguinis rule. So why would they have done that? And if they were going to invent an entirely new kind of citizenship, like an American brand, why wouldn't we have seen more discussion of that in the debates?
I think you do. And I would say, I think the right way to conceptualize it, it is a modified jus soli. Because even the British sources don't just say you're born here, you're a citizen. They say you're born here and you have to be under the protection of the sovereign. You have to have a relationship of allegiance. Allegiance is the word in Calvin's case.
But they don't focus on the parents. It's the child. And your approach focuses on the parents' allegiance.
Yeah, I'm not sure that that's true of the 19th century
It seems a little
sources,
ambiguous,
but
and I'm going to ask your friend on the other side that question.
let me point out then that there are two criteria. One is birth on the soil, and the other is legiance or allegiance. What we have is birth on the soil.
I don't think this is necessarily a terrible question from Barrett. She's basically saying that if they were creating a new rule, they likely would have made a new, it is a little bit of a perplexing thing. This is, as far as whether you go by the soil, they're just born in the soil, or you go based on the allegiance of the parents. And they could have just said, we're taking one, I'm taking one of them, but they didn't take the jus soli. They didn't say we're going. Jus soli is basically the land dictates. The land is the law. So, as in soil, right? So, in jus, as far as justice is following, the law is following. So, I think she's asking a fair question here. It's not indicative to me that she's turned against, and she even said she's going to ask a similar question to the other side. So. This way, you can't really know where they stand until you hear them question the other side as well.
Because they are adopting a modified British rule. They are not going the French rule, that Vattel talks about, where it's like, who's the citizen? That had to be done by statute, as you pointed out, which it was in 1401. But what they've got is they say birth in the United States and subject to the jurisdiction thereof. That is talked about as allegiance, allegiance, allegiance in the congressional debates. But they were clearly not incorporating the British feudal monarchical conception of allegiance where it's indefeasible. I mean, going back to the early 1700s, our nation had repudiated the notion that citizenship is indefeasible. The expatriation statutes for the late 1700s reflect that. And again, you look at the 1868 congressional report that we cite there, this is the same group of congressmen, Republican congressmen, and they say things like the U.S. Constitution itself is proof that Blackstone's theory of allegiance was not accepted. So they accept birth on U.S. soil, but then they take the concept of allegiance and give it its Republican, Democratic, American understanding. And that's very, very, I think that makes a ton of sense.
Okay, and let's talk about its applications. So, there are some, I can imagine it being messy in some applications. So what would you do with what the common law called foundlings? The thing about this is then you have to adjudicate if you're looking at parents, and if you're looking at parents' domicile, then you have to adjudicate both residence and intent to stay. What if you don't know who the parents are?
I think there are marginal cases. That one, I think, has the benefit of being addressed in 1401F, where it talks about.
Yeah. But what about the Constitution?
Under the Constitution, domicile is a constitutional standard in all kinds of other situations.
Well, and it's hard.
Diversity jurisdiction, personal jurisdiction, sorry.
Well, yeah, and a personal jurisdiction, 1332, diversity jurisdiction. And the thing is, it has to be litigated because it turns on intent. And both the virtue of both jus soli and jus sanguinis, whichever one you pick, it's a bright line rule. How would it work? How would you adjudicate these cases? You're not going to know at the time of birth for some people whether they have the intent to stay or not, including U.S. citizens, by the way. What if you have someone who is living in Norway with their husband and family, but is still a U.S. citizen, comes home and has her child here and goes back? How do we know whether the child is a U.S. citizen because the parent didn't have an intent to stay?
I'd say make 2 points, one practical, one legal. The practical point is under the terms of this executive order, you don't have to because the executive order turns on objectively verifiable things, which is immigration status.
There you
Are
go.
you lawfully present but temporarily present, or do you have an illegal status? So those kind of taking evidence, so to speak, under subjective intent wouldn't be done. And as to the constitutional point, obviously domicile is baked into a lot of constitutional and legal concepts, and there may be situations where facts are determined. But if you look at the guidance that all the agencies did after this court in Costa said the agency could go forward and issue guidance, the guidance provides, I think, very, very clear, objective, verifiable approaches to doing this. And so as a practical matter, I don't think it's presented by this executive order.
Thank you, General.
Justice Jackson?
Good morning, General. So I guess I am looking at your position in this case, and it boils down to requiring us to do at least these two things. One is believe that the framers were not importing the common law rule and understanding of birthright citizenship. And the second is to believe that what they were doing was departing from that common law rule in the way that you suggest. That is, they were seeking to have this turn on domicile. I think you have a number of hurdles to accomplish those two things. One of which I think is that when we look at this court's case law, and no one I think has mentioned Schooner's Exchange, but it appears that that was an 1812 case in which it seems as though the court had already accepted at the time of the ratification of the 14th Amendment that the allegiance that you were talking about was the English common law rule. That, in other words, allegiance meant that you are covered by the laws of the jurisdiction, that you can rely on that jurisdiction's protection. That's what allegiance meant. Now you're saying today, no, allegiance meant something about loyalty or that kind of idea. But if the Supreme Court had prior to
No, they're not going to either.
Established that allegiance meant the common law definition, I think your first hurdle is to help us understand why we would believe that when the 14th Amendment was ratified, the framers weren't just incorporating what we had previously said it meant.
Page 572 of the congressional record directly addresses this. They say the concept of temporary and local allegiance from the Schooner Exchange is what is meant by, or temporary and local jurisdiction from the Schooner Exchange is what is meant by the word jurisdiction in the 14th Amendment. Senator Trumbull says, I thought about saying owing allegiance, but again, there's a sort of allegiance from persons temporarily resident in the United States, whom we have no right to make citizens. So he expressly and consciously rejected reliance on Schooner.
What do we do with, I mean, that's a debate, and it's not a discussion, very valid. But then we have a subsequent debate between Fessenden and Wade, where the same concept comes up, and it becomes clear, at least from Senator Wade's perspective, that that's wrong. So Fessenden, and I'm not sure whether these are senators, I apologize. Fessenden says, suppose a person is born here of parents from abroad temporarily in this country. Wade responds, the senator says a person may be born here and not be a citizen. I know that is so in one instance, in the case of the children of foreign ministers who reside near the United States, et cetera, et cetera. So it appears as though in that exchange, at least Senator Wade believed that the English common law understanding of what it means to have allegiance, to be a temporary person on the soil, was what was being adopted.
Yeah, that exchange strongly supports us. If you look at it in context, Senator Wade has introduced a version that says only birth on U.S. soil and doesn't have any allegiance or jurisdictional element to it. And so Senator Fessenden stands up and says, well, that can't be right, because obviously, what about the children of temporary visitors? It has this, it's another one of these statements that has this appeal to a background understanding that we all agree that the temporary visitors, their children do not become citizens. And then Senator Wade has to kind of backtrack and say, well, what are the children of ambassadors? And in the end, Congress does not adopt Senator Wade's proposal. So we think that to the extent you can draw an inference from that, the inference strongly supports.
All right, well, let me just ask you about why we wouldn't see in the 14th Amendment anything about parental allegiance. Several of my colleagues have talked about the fact that your view of this turns on what the status of the parents are, and not the child, as would the born in the United States view of it. Can you help us understand why we wouldn't expect to see a mention of parents in the text of this amendment?
I think it was well understood that, for example, children cannot, newborns cannot form domicile. So it follows every 19th century.
That assumes domicile is in the test. And I'm asking you, how do we know that Congress did adopt the test that you say it adopted?
Yeah, when you're looking at 19th century conceptions of allegiance, the notion that the allegiance, again, we say domicile is instantiating the concept of allegiance for aliens as opposed to citizen. All of that, the 19th century understands the newborn's domicile, its allegiance follows the allegiance of the parents. And I point out that their theory relies on parental allegiance as well, because they recognize the exceptions for, hostile invading armies, for tribal Indians, for ambassadors. Again, the child's allegiance status, even on their view, turns on the status of the parent.
What do we do with Professor Muller's amicus brief and the historical record and the fact that even at times in this country where we understood that the parents were...
I'm just going to say this. Every time I ever hear anyone question me about some terrible Jew doing some stupid, terrible thing in the future, I'm just going to be like, do you hold Ketanji Brown Jackson against black people? I don't think you do. I don't think you do. Don't hold some lunatic against me, some stupid crap, because, no one holds KBJ against black people, and properly so.
Layered enemies of the United States. I'm talking about World War II and Japanese internment. Babies born in that circumstance were given birthright citizenship. So it seems as though this concept of allegiance of the parents really wasn't driving birthright citizenship, at least at this period of our history. So are you saying this is wrong, or they shouldn't have gotten birthright citizenship?
Well, if they were domiciled here, yes, they should have. If they were temporarily present, then no. But the executive practice, we can see from the 1930s.
Oh my God, let me
How
answer your
does the
stupid
temporary
question,
presence run with your concept of allegiance? I'm not sure I understand.
You don't understand on anything.
Are you saying that only people who are domiciled here, as you define it, can form the necessary loyalty to the United States?
It's not allegiance is not a question of subjective loyalty.
Okay.
Oh, it is something it's a reciprocal relationship between the citizen, whether they want it or not, they have that allegiance. And I think it's powerfully...
On the basis of what?
Domicile. I mean, that's what it says in so many words in the Venus and the Pizarro. It says, look, if you're talking about an alien, if they're just temporarily passing through, no, they don't have allegiance. But if they've made it their permanent home, they become part of our political community, and they are analogous or akin to citizens.
All right, just quickly, because I'm mindful of the time.
And I'm an idiot.
What do you do with Wong Kim Ark's statement that birthright citizenship is applying, quote, independently of a residence with intention to continue such residence, independently of any domiciliation? I know that they use domicile, it's a fact in the case, but that's not a part of their holding. It's not what the reasoning turns on. Correct?
I believe you're quoting from page 693 of that opinion. It goes on to say, not citizen terms on that, but the duty of obedience to our laws. It doesn't take the further step at that point and say, therefore, if you have temporary and local allegiance, you're a citizen. And immediately before that, you have that page 693 summary of the court's holding, where it says
you say
domicile,
Wong Kim Ark incorporates a domicile requirement.
That is the holding. It's definitely clearly expressed in the holding.
All right, one final thing, perspective. You say perspective, we're supposed to do this. Don't worry about the people who are already here and who would not qualify under your rule. How does this work? Are you suggesting that when a baby is born, people have to have documents, present documents? Is this happening in the delivery room? How are we determining when or whether a newborn child is a citizen of the United States under your rule?
And I think that's directly addressed in the SSA guidance that's cited in our brief. What SSA says is there's currently a system where, for example, social security numbers are generated based on the birth certificate. They say this can still be, for the vast majority of instances, completely transparent. You will still get a...
No, not transparent. I'm just talking about the particulars, because now you say your rule turns on whether the person intended to stay in the United States. And I think Justice Barrett brought this up. So are we bringing pregnant women in for depositions? What are we doing to figure this out?
No, as I pointed out earlier, the executive order turns on lawfulness of status. So if you give birth to a baby in the hospital right now, it gets the birth certificate in the system. There's a computer system.
So there's no opportunity. There's apparently no opportunity then for the person to prove or to say that they actually intended to stay in the United States.
Absolutely not. The opposite is true. Their opportunity to dispute if they think they were wrongly denied, which would only happen in a tiny minority of cases, is directly addressed in that guidance.
After the fact.
Yes.
After their baby has been denied citizenship, then we can go through the process.
Yes. And the way that, I'm summarizing because I'm not an expert.
Yes.
computers, but there's a computer program that currently automatically generates a social security number. SSA says, look, a social security number, non-citizens can have them if they have work authorization, so it doesn't prove citizenship. We'll give you a social security number, provided that the system automatically checks the immigration status of the parents, which there are robust databases for, and then it appears no different to the vast majority of birthing parents.
Thank you.
Thank you, counsel.
Okay, just to pause for a moment. What we've seen so far, sorry, I had to take care of some eye drops there for a moment. What we've seen so far is obviously KBJ and the liberal justices are going against this. So let's focus for a moment. So far, it seems as if John Roberts and Gorsuch are against this. Amy Coney Barrett are against him, against the executive order. Kavanaugh seemed surprisingly okay. Barrett even seemed like, her questions to me could have been much rougher. So right now, Gorsuch seems to be the real problem as well as Roberts. But it's still early. We need to see how they question the other side, because sometimes they're just in a feisty mood and they're just questioning everyone aggressively. But that's my take so far. And obviously, I'm chalking up Alito and Thomas is going along with the EO.
Ms. Wong?
Mr. Chief Justice, and may it please the court, ask any American what our citizenship rule is, and they'll tell you, everyone born here is a citizen.
That's a stupid argument.
That rule was enshrined in the 14th Amendment to put it out of the reach of any government official to destroy. When the government tried to strip Mr. Wong Kim Ark's citizenship on largely the same grounds they raised today, this court said no. 30 years after ratification, this court held that the 14th Amendment embodies the English common law rule. Virtually everyone born on US soil is subject to its jurisdiction and is a citizen. It excludes only those cloaked with a fiction of extraterritoriality because they are subject to another sovereign's jurisdiction, even when they're in the United States. A closed set of exceptions to an otherwise universal rule. My friend has now clearly said that the government is not asking you to overrule Wong Kim Ark. That is a fatal concession, because Wong Kim Ark's controlling rule of decision precludes their parental domicile requirement. The dissent understood that, and the majority tells us 6 times in the opinion that domicile is irrelevant under common law. Lynch versus Clark was already the dominant American case on citizenship, and it held that the US-born daughter of temporary visitors from Ireland who took the baby back to Ireland with them, that daughter was a US citizen. Authorities, including Lincoln's Attorney General and Kent's commentaries, embraced Lynch, and Kent specifically talked about temporary sojourners' children being US citizens. Justice Field said in 1884 that reflected the general understanding. That understanding was confirmed by Congress with its 1940 Act. The 14th Amendment's fixed, bright-line rule has contributed to the growth and thriving of our nation. It comes from text and history. It is workable, and it prevents manipulation. The executive order fails on all those counts. Swaths of American laws would be rendered senseless. Thousands of American babies will immediately lose their citizenship.
Nope.
And if you credit the government's theory,
No one alive will lose their
millions
citizenship.
of Americans,
It's
past,
prospective.
present, and future, could be called into question.
It's retarded.
All of this tells us the government's theory is wrong. I welcome the court's questions.
I'll tell you, that's a very weak opening. She's basically saying this is what public opinion has been. This is. I thought her arguments would be much stronger. Her arguments in favor are relatively weak. It's surprising that this is such a struggle for these justices to come along. That was terrible.
There are 5 exceptions
Get
to
her.
citizenship that you do accept.
Get her.
Yes, depending on how many you count, Justice Thomas, how you count them.
What is the underlying rule of law that you use to connect these 5 exceptions?
Sure. So as I just said, all of the exceptions involve situations where that US-born child is not subject to the jurisdiction of the United States because that extraterritoriality, the fiction of extraterritoriality,
Yes.
the interaction of another sovereign between the United States' jurisdiction and that person applies to the child as well as to the parent. Everyone else born in the United States is subject to the United States' jurisdiction. To answer Justice Barrett's question to my friend, that's what sets those exceptions apart from other US born persons.
We've heard a lot of talk about Wong Kim Ark, and you dismiss the use of the word domicile in it. It appears in the opinion 20 different times, and including in the question presented and in the actual legal holding. And the government doesn't want it to be overruled because it's willing to rely on that particular fact in that case. Isn't it at least something to be concerned about, to say that since discussed 20 different times and has that significant role in the opinion, that you can just dismiss it as irrelevant?
Well, Mr. Chief Justice, I think we have to look at what the controlling rule of decision is in Wong Kim Ark. Justice Gray takes pains in the majority opinion to set out his analysis. He first starts with a premise that in construing the 14th Amendment Citizenship Clause, we look to the English common law. That was the rule that applied from the colonial era on, at least for the colonists and for European immigrants. He then says, look, Chief Justice Marshall tells us in the Schooner Exchange what subject to the jurisdiction means. Again, looking to the English common law. Under English common law, if you are born in the dominions of the sovereign, you owe natural allegiance. And those who are present in the dominions of the sovereign owe temporary allegiance for as long as they're present. The only exceptions, again, at common law were ambassadors, people born on foreign ships, and people who were born during periods of foreign occupation. He then gets to the government's favorite page, 693, where he says, look, we have had this rule in the United States as to citizenship, at least for white Americans, from before independence. The purpose of the 14th Amendment was to embrace that universal rule of birthright citizenship, to embrace and incorporate the common law exceptions with the single additional exception of the pre-existing exception for tribal Indians that we had in the United States, which is an analogous exception, and that's the closed set of exceptions. You can't make sense of the holding in the case without looking to the controlling rule of decision, which is the common law. And I think my friend agrees that under English common law, domicile was not relevant, and the children born to temporary visitors in the territory of the sovereign were always considered birthright citizens.
Well, Ms. Wong, I mean, everything you say strikes me as, yeah, that's the way I read it too. But then what are those 20 domicile words doing there? Like you can, take some of them and say, they were just summarizing the facts of the case, but not all of them. And why did they keep on, why did they sprinkle that in the opinion?
Well, I think,
I agree.
again, those were the stipulated facts in the case.
In the
And
case,
it's clear we have textual evidence in the majority opinion that they were simply saying this is an a fortiori application of that controlling rule that comes from the English common law. Justice Gray writes, again, after setting out the English common law rule and the exceptions with the single additional exception for children of members of Indian tribes, that the amendment in clear words and manifest intent includes the children born within the territory of the United States of all other persons of whatever race or color domiciled within the United States. And as was pointed out earlier, the very next part of that same paragraph, he cites to Webster talking about Thrasher's case. And he says, people who are born in this country owe allegiance independently of a residence within, foreign nationals owe allegiance independently of a residence with intention to continue such residence, independently of any domiciliation, and independently of taking any oath of allegiance, which is totally contrary to both the government's theory of dual allegiance or partial allegiance and to the theory of domiciliation.
I mean, I might agree with you if domicile had simply been sprinkled in the opinion, But in Wong Kim Ark, it's a long
This is good.
opinion, but it begins by saying, here's the question, and it ends by coming back to the question. And
So you're saying it's not part of it.
Here's the question.
They said,
stated at
here's the
beginning of
question.
opinion, namely, whether a child born in
This
the
is Roberts. I told you. Sometimes, Roberts was very tough on the government in trying to uphold it. He's being really tough on the petitioners trying to knock it out. So that's what I'm saying. We don't know where Roberts is at right now, and he's a real toss-up.
United States of parents of Chinese descent who at the time of his birth are subjects of the Emperor of China, but have a permanent domicile and residence in the United States and are there carrying on business. And he states
Is it Alito?
diplomatic
Is it Alito? Before she referenced Mr. Chief Justice, their voices sound very similar to me, Alito and Roberts.
exception. And he says, for the reasons above stated, this court
She
is of
referred
the
to him as
opinion
Mr. Chief
that
Justice.
the question must be answered in the affirmative. So why put domicile in? Sometimes it's
This
hard to
does
figure
sound
out
like
what is
Alito
the
now.
holding of the case. Here he tells us this is the holding of the case. Why put domicile in there?
Well,
It's just something, it's something irrelevant that he wanted to throw in. It's like, whether a child born in the United States of parents of Chinese descent who once resided at a particular address in San Francisco, who attempted to enter the country at the port of San Francisco. Why put it in if it's irrelevant?
Well, Justice Alito,
There you go.
I'll give you
There's
two
Alito.
responses. The first is that, again, it was a stipulated fact. The second is that regardless of what the judgment in the case was, which again was an a fortiori application of the rule of decision, the rule of decision in Wong Kim Ark has binding precedential effect. Even if you think that Wong Kim Ark decided the case based on the stipulated facts, you have to follow that controlling rule of decision. And if you follow that rule,
But
you get to the same result
friend
for people without domicile.
is saying his
Wong
father
Kim Ark
favors him.
says
Stupid.
6 times in the first parts of the opinion, as well as on the page the government focuses on, that domicile is not relevant.
Well,
That
Ms. Wong, on that, what do we do with the fact that after Wong Kim Ark, at least some authorities took the view that the non-domiciliary question wasn't decided, remained open, and even continued to press the view that domicile is required? Now, I know you've got a lot of good stuff on your side too, but what do we do with the fact that many sound legal authorities thought it remained an open question, even if one of them wasn't John Marshall Harlan?
I liked your example from Justice Harlan's lecture here in DC. So here's what I would say. All of the government citations in their brief generally either were rejected by Wong Kim Ark expressly if they
I'm talking
predated Wong Kim Ark.
post. If we're trying to understand how the legal community understood what happened in Wong Kim Ark,
Sure.
it seems to me it's a mess.
So
Maybe you can persuade me otherwise.
I think I can, Justice Gorsuch. First, as to the post-Wong Kim Ark authorities the government cites, each one of them is inconsistent with Wong Kim Ark's reasoning or doesn't mention it at all. Most of them have very little reasoning at all. And in contrast, what we have on our side post-Wong Kim Ark is numerous federal court decisions around the time of Wong Kim Ark, between ratification and Wong Kim Ark, that said that domicile is not relevant. They cited Lynch versus Clark, which again was about the daughter of temporary sojourners. We have the 6th edition of Kent, which was cited in Wong Kim Ark, and of course was then cited after Wong Kim Ark was decided by many authorities, again, discussing temporary sojourners. Anyone who wanted to know what the law of citizenship was under the 14th Amendment after Wong Kim Ark would go to the 6th edition of Kent, where he says in that footnote on page 38 that the rule was Lynch versus Clark and temporary sojourners' children are US citizens. We have members of Congress speaking on the record on debates on immigration laws, where they were finally passing these immigration restrictions that Senator Cowan wanted. And they all stated either that Lynch was the rule, that Attorney General Bates had stated the rule, again, citing Lynch, or Kent, and stating the rule that everyone born in the US is a citizen, and saying, look, the children of Chinese immigrants, these immigrants who are unwelcome, these immigrants that Congress is now trying to bar from entering the United States, if their children born in the United States are citizens. We have an 1896 So a couple years before Wong Kim Ark, but in 1896 State Department regulation, which said the US-born children of foreign nationals are US citizens, accepting only the children of ambassadors. And then you have Marshall Woodworth, who is a US attorney who writes in a law review article that he's talking specifically about temporary sojourners' children. And he says, I don't think that's a good rule from a policy perspective, but that's the general rule.
Ms. Wang, can I
Yes.
offer a possible explanation for why Justice Gray made a point of putting domicile in what he said was the holding of the case? And it is this. Wong Kim Ark and his parents, had they come to the United States from Europe, could have been naturalized. But because they were Chinese, they could not be naturalized. And they had done everything that they could to make themselves Americans by establishing a domicile in the United States. And so that's what this was about. He couldn't get naturalized because of a racist law, but they had done everything they could to become part of the American society. At the same time, there were many, many men who were horribly exploited, brought to the United States to work on the Transcontinental Railroad, to work in mines.
Who never tried becoming citizens.
They were worked to death. They were treated horrifically, but they were not, they were overwhelmingly men. There wasn't an indication that they would stay here, they could stay here, they didn't have permanent homes. And the opinion is drawing a distinction between those two categories of people who would have been well understood at the time when Wong Kim Ark was decided.
No, Justice Alito, I don't think that's a plausible explanation for why
the
domicile
obvious
is mentioned
explanation
in Wong Kim Ark, because again, the controlling rule of decision based on the English common law and cases from Schooner Exchange to Lynch versus Clark to State versus Manuel, which was the North Carolina decision that said, look, the rule in the United States from independence on has been the English common law rule. That explanation would be inconsistent.
But Ms. Wong,
yes.
isn't that explanation, I take Justice Alito's point, and I think he actually makes a good one in the sense that it could be that Justice Gray emphasized domicile to help the public accept the outcome of this case. You're suggesting that the emphasis on domicile was not a part of the rule, meaning he wasn't saying you had to be like a foreigner who is doing everything they can and who can't be naturalized, but he might have emphasized those facts in this case precisely because Chinese immigrants were unwanted, precisely because he had to get this out into the public and people were going to say, whoa.
No, simpleton, not because they were merely unwanted, because they had there was zero opportunity. There was a specific law, the whole Wong Kim Ark case, they keep talking about it, so I should just share this with you, okay? I'm going to pause for a full 60 seconds so you can understand the Wong Kim Ark case. The Wong Kim Ark was a Chinese, was of Chinese origin, living in America at a time that there was a law which prohibited any Chinese from becoming citizens. His parents had lived in the country for like a couple of decades. He was born here and his parents had lived here for a couple of decades, and they declared themselves as permanent residents of the country, but they could not apply for or become citizens because there was a racist law which prohibited Chinese people from becoming citizens. He left the country, and when he came back in, the government said, you can't come back in here, you're not a citizen. And that's when they said, basically, because they've done everything they can under the law and lived here for 20 years, you can't, basically, you can't deny him his citizenship under the 14th Amendment. So they point, so the petitioners, this woman and her side, the people fighting Trump are pointing to Wong Kim Ark to try and say, well, look, since Wong Kim Ark over here says that you're born here, that it works for you. And in that case, that's now what's controlling. The John Sauer and Trump's attorney are basically saying, no. The whole point here is, and that's what Alito is pointing to, that look, they just couldn't find any way to become a citizen. And now they're born here and they couldn't find any way to become a citizen because we had a racist law on the books. That's the only reason. But that actually stands for the point that the reason that Wong Kim Ark was found in favor of the petitioner there, that he is recognized as being a citizen of the 14th Amendment, is because there's all these different steps that they're taking to try and get citizenship. And it's not merely just being born on the soil. It's not jus soli, as Amy Coney Barrett would pronounce it. So that's why John Sauer is like, no, Wong Kim Ark helps us. And the other side is saying Wong Kim, that's why this is all a battle over how do you understand Wong Kim Ark. And that's why you're seeing this back and forth here. I hope for those of you who are not understanding that can now understand. Wong Kim Ark was the name of the guy. That was just his unusual name. So, but that's why they're talking about Wong Kim Ark, because ultimately, however you read Wong Kim Ark is going to determine this case. And John Sauer, I think, correctly interprets it as saying that there's no such thing as birthright citizenship under the 14th Amendment. There has to be more to it than that. And the petitioner here is saying, no, look at that. He was born in the soil, and completely ignores all the efforts to domicile himself and for his parents to domicile themselves here permanently and give up their allegiance to China.
You're saying these people have to, this baby has to be a citizen? And so one could imagine that it was important from a standpoint of helping people accept this citizen rule under these circumstances to emphasize that these particular people in this case were in Justice Alito's first category.
I think that is very possible, Justice Jackson. And as evidence of that, I would point to the fact that if you look at the briefing in Wong Kim Ark, you'll see that even though the parties had stipulated in the district court that Wong Kim Ark's parents were domiciled in the United States, when the case came to the Supreme Court, the government's brief argued that it was impossible for Chinese immigrants to have domicile because they expressed the view that was common among people who opposed immigration by Chinese nationals to the United States. There was a common view that Chinese people were inherently temporary sojourners in the country. And so I do think it's possible, Justice Alito and Justice Jackson, that he was trying to dispel that notion and tell the government.
Absolutely, that at least it reads as though he's trying to calm everyone down. These particular people were domiciled, but we're following the English common law rule. And when you look at the English common law rule, domicile is not a factor.
That's right. I think, you know, who knows why the majority opinion mentioned domicile. We know is a stipulated fact.
We all know
the
why.
Government tried
who
to
knows
renege
why?
on that stipulation
What a stupid.
and rely on this.
Who knows why? We all know why. Because John Sauer's right.
Advocates at that time.
Who could
that
tell?
Chinese people couldn't form a domicile in the United States, and he followed the English common law rule.
Ms. White, can I move? Oh,
Go ahead.
I just wanted to ask you a question about how the exceptions fit within the general rule. You've called them exceptions, and some of the common law sources call them exceptions. So I take that point. But if we think of use solely as tied to the territory, and we look at the exceptions as territorial in a sense, then they seem kind of like natural outgrowths of that rule. And this is what I mean. And this is where I want your help with how the exceptions played out in practice. If you look at Indian reservations as unique places because Indians were quasi-sovereigns, separate nations in the American system. If you look at occupied alien territory as territory that's outside the jurisdiction of the United States. And then if you look at the diplomatic exception, almost like diplomats and their children had little bubbles around them, like the embassy is really the territory of that country. And even when they're traveling around, they're all not subject to the jurisdiction by virtue of this territorial fiction. Are those just applications of the rule? And if they are, then what happens to alien enemies like the German spies in Ex parte Quirin, or what happens to Indians who are actually not on the reservation but may be born, say, in Baton Rouge? How does the rule apply in those situations? Does it travel with the person, or is it tied in some sense to the land?
Sure. So let me answer each part in turn. So the thing that all of the exceptions have in common, again, is this sense that The person has this fiction of extraterritoriality around them. Let's set aside the Indian tribal exception for a moment and come back to it. So the example of enemy aliens, for example, ex parte Kieran, is one that is answered by Justice Story in both Inglis and in Rice. And the touchstone under the American application of English common law was that in wartime, the touchstone is whether there's a foreign occupation of US territory. So,
And that's, just to interrupt for 1 second to
Sure.
clarify, and that is territorial. Sometimes it just seemed to me that the rule varied. Sometimes it was stated as enemy alien, and sometimes it was focused on occupied territory.
Sure. So the rule, I don't think there's a separate rule for enemy aliens, and the government's briefs describe the exception as an enemy alien exception.
Agree.
I don't think that is the best way to think about it. Rice and English tell you that when the British forces are occupying Castile, Maine, no one is subject to US jurisdiction there because Britain is governing Castile, Maine. And Justice Story explains, look, if the US then retakes that territory, babies who are born to US citizens by what he calls post limine become US citizens. So that's the way to think about any wartime situation, enemy aliens or otherwise. As we heard earlier, Professor Muller's amicus brief tells us how we've thought about enemy aliens in wartime. Even in World War II, when the United States was detaining Japanese nationals who were deemed enemy aliens of the United States, when those enemy aliens had babies in these detention camps, everyone agreed that those babies were US citizens. And Professor Muller goes on to explain that there are many cases of those US citizens going on to a lifetime of government service to the United States. Everyone agrees those babies are US citizens like everyone else. So again, the touchstone for enemy aliens.
The babies because they can't go back.
So
Is
what
there an
about
occupation?
Indians? What about the Indian who's off the reservation or born off of a reservation?
Sure. So to start with the basics, I'll refer to the Indian tribal exception just to use the term of art. The Indian tribal exception, Elk versus Wilkins tells us, comes from the constitutionally unique status of Indian tribes. In the Indian Commerce Clause, we know that tribes are treated as basically quasi-sovereign nations. We know that from the Marshall trilogy of cases. We know from Worcester versus Georgia, where Chief Justice Marshall said that the tribes are essentially a distinct political community.
Well, I understand all that. So just in
Sure.
the entrance of time, just to
Sorry.
focus you, how I understand why the Indians are treated differently for purposes of the law, but I want to know, is it tied to territory or is it tied to the status of someone as a member of a tribe? Because if you're looking at it because of the special relationship of Indians to the United States as a matter of the Constitution, et cetera, well, I mean, citizens of France are citizens of a different sovereign as well.
Sure. So Elk versus Wilkins doesn't really answer that question. The court says there are two ways to look at this. Either you look at it as the tribal member is like an ambassador, or you can look at it like there's a territoriality issue where people are born on tribal lands, and therefore they're essentially, I think he says, Justice Gray says at one point, we might as well be talking about someone who's born in Mexico.
Well, there's a lot
I
in
agree.
Elk, and some of it's not terribly helpful for you, it seems to me, because Justice Gray, again, strikes again, says that they may be subject in some degree or respect to the United States. So there's some jurisdiction. He says they're born in the geographic limits. They are in a geographical sense born in the United States. But because they are not completely subject to the jurisdiction of the United States and owe allegiance distinct from the United States, that's what takes them outside. And that language sure sounds a lot like the Solicitor General's presentation today.
To the contrary, Justice Gorsuch, I embrace that part.
See, Gorsuch now this is what I told you. When they start questioning the other side, you start getting a different flavor for where they're holding. Gorsuch was very tough on Trump's attorney, and now he's being tough on the other side. So he sounds like a toss-up to me right now.
of Elk versus Wilkins is holding. Justice Gray, of course, wrote both Wong Kim Ark.
I know, and it's a struggle.
Sure. Let me try to help you out with that. You know, the government tries to make it seem as though what sets the exceptions apart, what defines the exceptions, is that the government has some maximum theoretical power. The government could have exercised plenary regulatory power over the tribes, and therefore that's the same situation as a foreign national in the United States. But that's actually not true, because remember, if there's always this background notion, whatever the parameters of the relationship between the United States government and tribal nations at that time of ratification, there was this constitutionally distinct status of the tribes and tribal members, setting them, excluding from apportionment, which was renewed in the 14th Amendment. And that's not true of foreign nationals. If the government were right that the question is what's the maximum theoretical power the government has, there would be no ambassador exception, because of course the United States could decide in some instance to go ahead and prosecute an ambassador. There would be inter-sovereign comity considerations there. That's how you define the exceptions. And as Wong Kim Ark says, Elk versus Wilkins has no bearing on the question of foreign nationals.
Ms. Wong, on the earlier answer you gave to Justice Gorsuch on the temporary sojourners cases, those were distinct cases, correct, where the parents had come to the US and didn't want to give citizenship to their kids, took them out immediately, correct?
See, the question when you follow up with correct, just tell me yes, because that helps you. I'm helping you. Whenever you hear justice saying that, just know they're basically saying, come on, I'm feeding you an answer here.
I'm sorry, Justice Sotomayor, I'm not sure which cases you're referring to.
All right, that we can look at.
Okay.
Ms. Wang, would you agree that the citizenship test in the 14th Amendment is the same as the test in the 1866 Civil Rights Act?
So the words are obviously different. What Wong Kim Ark tells us and what the debates tell us is that the framers, it was the same Congress obviously framing both. Congress was trying to do the same thing with both the 1866 Act and with the 14th Amendment. They wanted to capture the common law exceptions and the Indian tribal exception. They started out with the two separate phrases, not subject to any foreign power, plus excluding Indians not taxed. And as Justice Gray described it in his majority opinion in Wong Kim Ark, they decided to switch to the affirmative phrase, subject to the jurisdiction.
Yeah, well, do they mean the same thing? And wouldn't it be very odd if the citizenship test in the 14th Amendment were broader than the citizenship test in the 1866 Civil Rights Act, particularly in the light of the fact that the 1866 Civil Rights Act was reenacted after the adoption of the 14th Amendment and remained in place until 1940.
Sure, the framers were trying to do the same thing with the language in both.
Okay, so then I think we can turn to the language of the 1866 Civil Rights Act because it's more straightforward. Subject to the jurisdiction thereof is like the puzzle wrapped in an enigma, wrapped in a mystery, but not subject to any foreign power is pretty straightforward. So let me give you these examples. A boy is born here to an Iranian father who has entered the country illegally. That boy is automatically an Iranian national at birth, and he has a duty to provide military service to the Iranian government. Is he not subject to any foreign power?
Not within the meaning of the 1866 Act, Justice Alito. And that's clear from Wong Kim Ark, and it's clear from the debates. What the framers meant by the phrase not subject to any foreign power was referring to the ambassador exception. If it meant what the government contends, basically not a subject of any foreign power, that another country considers you a jus sanguinis citizen, then lawful permanent residents, all foreign nationals.
Well, ordinary public meaning of that would certainly encompass that boy, would it not?
Justice Alito, if you think that the language of the 1866 Act was ambiguous, as Wong Kim Ark says, the shift to the language of the 14th Amendment, which is the operative text, certainly clears up any ambiguity.
What I said about a boy born to an Iranian father is true of children born here to parents who are nationals of other countries. If I'm correct, it's true to a child who's born here to Russian parents. It's true to a child who's born here to Mexican parents. They're automatically citizens or nationals of those countries and have a duty of military service. It sure seems like that makes them subject to a foreign power.
But again, Justice Alito, that would have meant that the children of Irish, Italian, and other immigrants, which Wong Kim Ark refers to and the framers refer to, would not have been citizens either. Because if the only test is whether that US-born child is considered a citizen by another country under their jus sanguinis laws, then no foreign nationals' children would be.
In all of those cases, the parents could be naturalized, and then the children would be derivatively naturalized when the parents were naturalized.
Very simple.
Wong Kim Ark.
Nothing? She's got nothing?
Wong Kim Ark has a passage explaining how this court should treat dicta. And it quotes something that John Marshall said. It is well, this is quoting from Wong Kim Ark, it is well to bear in mind the oft-quoted words of Chief Justice Marshall, it is a maxim not to be disregarded, that general expressions in every opinion are to be taken in connection with the case in which those expressions are used. If they go beyond the case, they may be respected, but ought not to control the judgment in a subsequent suit when the very point is presented for a decision. So
there you go. Stop relying on dicta.
Does that fall within the, what's good for the goose is good for the gander rule? That's how Wong Kim Ark treats what was said in the slaughterhouse cases. Should we apply that same rule to Wong Kim Ark itself?
Wong Kim Ark tells you what to make of the slaughterhouse dicta. It was dicta. The issue of citizenship was not at play in slaughterhouse. And in contrast, the parts of the holding, the parts of the decision that I alluded to are the controlling rule of decision. Again, we look to the English common law in construing the 14th Amendment.
Thank you, counsel. Justice Thomas, anything further, Justice Alito?
Well, just a couple more questions. So if
he's not done,
those who framed and adopted the 14th Amendment had wanted to limit
that case was from the early 1900s.
Test
like
to
1908,
just
he was
those
20 then.
Specific groups that
by my recollection
you concede fall outside the birthright citizenship rule. Why didn't they refer specifically to those groups? Why did they adopt a general rule? They could have said all persons born or naturalized in the United States, excluding Indians not taxed, and those ineligible under common law are citizens of the United States and of the state wherein they reside. Or they could have said all persons born or naturalized in the United States, excluding Indians not taxed, and the children of foreign ambassadors or foreign invaders are citizens of the United States and of the state wherein they reside. But they didn't do that. They adopted a general rule. So what's the explanation?
I would say the Wong Kim Ark tells us what the explanation is, that the framers of the 14th Amendment, after overriding President Johnson's veto, wanted to adopt a universal rule with a closed set of exceptions. And they believed that subject to the jurisdiction of the United States did that. And that term does describe both the universal general rule and the common law exceptions, with the sole additional American exception for tribal Indians.
Thank you.
Justice Sotomayor?
Ms. Wang, I've not quite understood the Solicitor General's argument that lawful domicile somehow changes the U.S.'s
She's trying so hard to help bail her out.
Dominion
like
over
taking
a
buckets of
person
water,
or
throwing
allegiance. Even in Justice Alito's examples, if your parents are Iranian, if you get lawful permanent residency here, that child still, by their laws, when it leaves the United States, must serve in the Iranian army, correct?
I think Sotomayor wants to shove this woman away, which I think ironically is Ms. Wang arguing about Wong Kim Ark. So I think Sotomayor is feeling like, just shove over. I'm going to argue this case for you. You can just move aside. I'm going to take this case.
Well, I don't know the answer to that. What I can tell you is that under Wong Kim Ark, the court says, we don't care about problems of dual nationality.
Is going
we
nuts.
don't look to other countries' laws in construing our 14th Amendment.
How many ways can I help you?
It was undisputed there that Wong Kim Ark's parents owed loyalties to China, correct?
Sure, yes.
What I'm saying is, even if you become a permanent resident, you're not a U.S. citizen. So your
Correct.
primary loyalty still remains with your citizenship country, wherever you came from.
That's right, Justice Sotomayor. I take your point now.
You understand what I'm saying? And during temporary, whether it's lawful or unlawful, temporary presence in the United States, you are subject to the U.S. laws, correct?
That's right. The question that the 14th Amendment asks is whether the U.S.-born child is subject to U.S. jurisdiction when they're born.
Meaning, are they within the U.S. territory?
Exactly, other than people covered by that closed set of exceptions.
Okay, thank you.
That's right. In other words, the government's rule, which really is looking at whether someone has a divided allegiance because they're a citizen of another country, would exclude the children of all foreign nationals. And that isn't what they're saying.
Exactly. So the only way that allegiance, lawful or unlawful, has no play in this question.
I would say that the relevance of allegiance is the relevance under the English common law rule that's embodied in the 14th Amendment. All persons born in the territory of the sovereign owe natural allegiance.
Except for the three limited exceptions.
Precisely.
Justice Kagan?
I think I'd like to take you back to the first question that Justice Alito asked General Sauer, and it was this question of, what do we do if we think we have a new problem that didn't exist at the time of the 14th Amendment? I don't think actually that the U.S. government argues the case this way, but let's put the U.S. government's arguments aside and just ask something like, well, everything that you're saying would suggest an answer to the question of people who, the children of people who are temporarily in the U.S. but here lawfully. Is there any way that there might be a different answer with respect to the children of people who are here unlawfully because of this new problem issue that Justice Alito has raised?
No, there is no difference. And of course, the government's arguments as to people who are unauthorized immigrants in this country all runs through and hinges on their domicile requirement. The first thing I would say in response is that, once again, it's crystal clear from Wong Kim Ark and from the debates that the framers of the 14th Amendment meant to have a universal common law rule of citizenship subject to the closed set of exceptions. And we can't take the current administration's policy considerations into account to try to re-engineer and radically reinterpret the original meaning of the 14th Amendment. The second point I would make is that, in fact, the framers did consider the concept and the actual problems of immigration that were coming up at that time. In addition to this, notable exchange between Senator Cowan and Senator Conness, where Cowan says, if we have this citizenship clause as part of the Constitution, we are going to encourage these gypsies, what he called gypsies, Roma, in Pennsylvania, whom he characterized as invaders, trespassers, and lawbreakers, will encourage them to come into our country because their children will be citizens. He says, Senator Conness, in your state of California, you will be facing a mass flood of Chinese immigration if we adopt the citizenship rule. And Senator Conness himself, an Irish immigrant, says, yes, and I am voting for that because I believe in citizenship by virtue of birth without regard to parentage. And the third point I would make is a historical one, which is that recall that at the time the framers are thinking about birthright citizenship, there just been 15 or 20 years of unprecedented immigration from Ireland. The Know Nothing Party was dominant in the 1850s, just a decade earlier.
They
And
call that
they
the
were
Democrat Party
vehemently
today.
opposed to Irish immigration. They believed Irish Catholic immigrants were unassimilable and could never become Americans. But even the Know Nothing Party members of Congress believed that the children born in the United States to those Irish immigrants were citizens like anyone else. That's the intuition that the framers of the 14th Amendment had. Contrary to the government's arguments now, they wanted to grow this country. They wanted to make sure we had a citizenry to populate the military, to settle the country. And they also had an intuition that was consistent with the founding aversion to inherited rights and disabilities.
Thank you.
Justice Gorsuch? Justice Kavanaugh?
On Lynch v. Clark, which you cite several times in the briefing today, which I appreciate, the government's response is that that decision was questioned at the time and went unmentioned in congressional debates about the 14th Amendment. I just want to get your response to that point on Lynch.
Sure, not true, though the Lynch was not specifically mentioned by name in the 14th Amendment debates. It was a couple months earlier in the debates on the 1866 Act, where Senator Lawrence talks about the great case of Lynch versus Clark, where it was conclusively shown that all children born here are citizens without any regard to the political condition or allegiance of their parents. And then, of course, they discuss the children of temporary sojourners elsewhere without mentioning Lynch.
Just want to isolate a point that you've mentioned, which is if the 14th Amendment used the phrase not subject to any foreign power, you have a much tougher argument. And then earlier, I think you indicated that
This isn't sounding good from
that's what
Kavanaugh.
they meant, even though they didn't say it. I just want to give you a chance to unpack that, because I think that's
Sure.
If it said that, I think our history would be a little different. And I think the text, even put aside the histories, because that's speculation, the text would be quite a bit different.
Sure. So let me answer in three parts. The first is that Wong Kim Ark tells us that the court already dealt with this and said, look, the framers were trying to do the same thing with the language of the 1866 Act. To the extent you think that the language is ambiguous or not as good, let's look at the operative text subject to the jurisdiction thereof. The second point I would make is that it's clear from the debates that the framers, in using the phrase not subject to any foreign power, were thinking about ambassadors. And I believe that Senator Wade at one point says, well, I wanted to start with the phrase, all persons born in the United States are US citizens. But then I thought, oh wait, we have these temporary visitors. In fact, the government points to this quote. He says, so there are these temporary visitors we can't make citizen, and we can't make their children citizens. That's ambassadors, and that's very clear from that.
So if that had been the text, your argument would be that was understood to be narrower than its text would read.
Yes.
But that's not the text, so I guess we don't need to deal with that.
Sure, and that brings me to my third point, which is you can't read not subject to any foreign power the way the government urges you to without making the children of all foreign nationals non-citizens. And that's clearly not what the framers were doing.
Justice Alito and Justice Kagan raised an interpretive question that I think is important, which is, are the exceptions, you've used the word closed many times, frozen, or do we reason by analogy to the exceptions that existed based on things that were unforeseen at the time? This comes up in the Second Amendment now, comes up in free speech law. And how do we think about whether it's possible that there could be an additional exception based on modern circumstances, reasoning by analogy to the exceptions that exist? I'm thinking in particular about the non-citizens unlawfully in the country, not the temporary part, but the non-citizens unlawfully in the country.
Sure.
Could you reason by analogy? You've used the phrase several times, I think, the fiction of extraterritoriality, and could that apply? And if not, why not?
Sure. So here, I agree with Professor Whittington, who says that the government's position here is not positing a new application of the rule, but a challenge to the rule itself. And I think that's right. We know that the 14th Amendment's rule does provide for a universal rule with a set of closed exceptions. Wong Kim Ark says so at least twice. It says in an earlier passage that the framers were not trying to introduce any new exceptions. To the contrary, they were trying to foreclose any caste-creating exceptions like the court had created in Dred Scott. The second reason we know this is that the debates themselves had the framers saying, number one, we are declaring what is already the law in this country, at least for white Americans, and we are putting any further exceptions to birthright citizenship outside the reach of any future Congress. They were very concerned about that. That's the whole impetus for the citizenship clause. And the third thing I would say is that that it would be contrary to the central purpose of the 14th Amendment citizenship clause to admit new exceptions. For all those reasons, the entire history of the citizenship clause is driven by the notion that we don't want to have any other exceptions.
And then relatedly, just a separation of powers point, but get your answer. I understand your point about the executive order, but Congress's authority under Section 5 of the 14th Amendment, I guess the answer you just gave means they don't have any authority to look at this, even if they passed it 435-0 in the House and 100-0 in the Senate and said, we're carving out a new, by analogy to the existing categories, a new exception. Your point is, no, they're closed, they're frozen forever.
Correct. And the way I would put it is that the citizenship clause of the 14th Amendment, again, has a universal rule with a closed set of exceptions. It sets a floor. So the Congress has, under the naturalization clause, the power to expand citizenship to other people not covered by the 14th Amendment. And obviously they have in many ways, but they can't go below that floor that the Constitution sets.
I think Mr. Sauer acknowledged that, and you mentioned this in your opening, that if we agree with you on how to read Wong Kim Ark, then you win. So that could be if we did agree with you on Wong Kim Ark, that could be just a short opinion, right? That says the better reading is respondent's reading. Government doesn't ask us to overrule, affirmed.
Yes.
That's that. Then last question though, why would we address the constitutional issue? This is the last one. Why would we address the constitutional issue given your argument on the statutory? Our usual practice, as you're well aware, of course, is to resolve things on statutory grounds and not to do a constitutional ground.
Sure. You know, I think we obviously have these two paths to a win here. We're happy to win on either or both of them. I do think it would be prudent for the court to reaffirm its decision in Wong Kim Ark, where it's a landmark decision about the definition of national citizenship in this country. I just think it would be prudent for the court to go ahead and reaffirm that, but of course we're happy to take a win on any ground.
Thank you.
Thank you.
Justice Jackson? I'm sorry, Justice Barrett.
So I have a question about the exceptions again. So in your interchange with Justice Kavanaugh just now, you were talking about it as a closed set of exceptions. And said that way, it sounds like exceptions that people had in mind at the time of the ratification, but that were not explicit in the amendment. But I took your brief to be arguing that subject to the jurisdiction thereof is the language in the 14th Amendment that refers to those exceptions. Am I right?
That's right.
Okay.
It describes them.
It describes them. And would you say, this goes back to a question that Justice Gorsuch asked General Sauer, our relationship to the Indian tribes is different today than it was at the time that the 14th Amendment was ratified. Let's put aside Section 1401. Is an tribal Indian born on a reservation today on tribal land a natural born citizen under the 14th Amendment?
Under the 14th Amendment, no. Of course, Congress has provided for citizenship for all tribal members in the
By
1924
statute,
Act.
by
That's right.
statute. And so is that because what's subject to the jurisdiction of meant when you say closed set of exceptions? It means that the jurisdiction as it existed at the time of the 14th Amendment is still the jurisdiction today?
So
So let me just be a little bit clear. Justice Kavanaugh asked you if we could create new categories by analogy. So there may be other sorts of people who were present here to whom this subject to the jurisdiction in the same way that we were talking about, the bubbles around ambassadors or the soil of occupied territory or the soil of tribal land. Perhaps those new carve-outs could exist by analogy today. Like if the United States carved out some portion of some state and suspended it from its jurisdiction. Wouldn't the principle still apply?
No, Justice Barrett, for two reasons. The first is, again, that there is a closed set.
But why is it closed? The language doesn't say it's closed.
Sure, we know it's closed because Congress's, the very purpose of the Citizenship Clause was to foreclose new exceptions. That's clear from the debates. And I would say that the language describes a closed set as well, because you can't imagine
an unspoken
another
set of
situation.
exceptions.
The government's
what's
trying to
closed?
make us imagine another situation.
Okay.
Right? They say, look, what if Congress, in order to do an end run, in order to change the meaning of the 14th Amendment as to unauthorized immigrants' children, Congress can say, we are not going to exercise jurisdiction.
Well, not quite, because it's redefining jurisdiction. It's not quite analogous, right? Because the government's domicile theory is a little bit different than the jus soli theory, right?
Sure, that's right.
Yeah.
I'm just saying that in the second step of their argument as to undocumented immigrants, where they have to get around the fact that undocumented immigrants, by and large, are domiciled in the United States, they're trying to say, look, we're gonna manipulate the law either to define domicile or to carve out, to say, just wave a magic wand and say these babies are not subject to the jurisdiction of the United States. There's still a missing factor under that original meaning of the 14th Amendment, and that's that there is another sovereign who can exercise jurisdiction over this person, even though they're in the United States. And this gets me back to a question you asked Justice Alito. The difference between an ordinary non-ambassador foreign national and everyone who's subject to one of those jurisdictions is that even if you take the government's
I'll give this later when we're
and say a
wrapping
foreign
up.
national is subject to
I'll weigh in
their
with
country
this
of
at the end.
nationality's jurisdiction in the United States is actually not true. If I'm a French national in the United States, France cannot come into the United States, arrest me, and try me for a crime under French law. And that's what sets ordinary foreign nationals apart from
Well,
ambassadors.
no, I mean, I understand. That wasn't quite the hypothetical. I understand
I'm
that. Let
sorry.
me just ask you, no, that's okay. Let me just ask you one last question about Indians. So I gather what you're saying is that Congress cannot expand the set of, we'll call them exceptions, right? But you're saying it can't contract them either, and that was the Indian example. So what if, again, putting aside Section 1401, what if our relationship with tribal Indians has changed so much that we would say, no, Indians really are fully subject to the jurisdiction of the United States in the way any other, natural-born citizen is? You're saying that that doesn't change the constitutional status of Indian citizenship.
Let me be clear. What I'm saying is that the meaning of the 14th Amendment is we have to go with the original public meaning. And obviously at the very time that the framers were, thinking about the 14th Amendment, at the time of ratification, that relationship between the United States and tribal nations was in flux, right? The
See, it's an interesting thing here that she's saying we have to go with the original meaning. The left typically, there's a lot of different ways of approaching the Constitution. The left typically, likes to look at the Constitution as if it's a living, breathing document, it should be reinterpreted all the time. They don't want it reinterpreted in this case because public policy dictates that the meaning that the respondents are trying to ascribe to this entire scenario is a disaster for our policy. So when they're saying it's a living, breathing document, all of a sudden it's not a living, breathing document. No, let's look back to the original text. Frankly, if you're approaching this from a healthy perspective, legal philosophical perspective, I think the original text doesn't work for them either. So, but I'll weigh in. I'll weigh in with my thoughts as to where everyone is by the end of this. Not that that and a hill of beans will get you somewhere.
Has made various arguments about Congress's authority, but the way the framers thought about it and the way that Wong Kim Ark describes it is that there was a unique constitutional status, unlike any other relationship between sovereigns in all the world, between the United States and the Indian tribes. And that is what gave rise to the pre-existing exclusion of Indian tribal members from US citizenship, and that's what the 14th Amendment captures.
Justice Jackson?
So I want to understand how you are responding to the government's argument that because temporary visitors and undocumented immigrants are still governed by their home countries, and in the government's take on this, you can't have you can have allegiance to two different sovereigns. Those groups can't have the requisite allegiance to be subject to the United States for the purpose of the 14th Amendment. That's what I hear the government saying. But I do think that that seems to rest on a different understanding of allegiance than what was in the English common law. And that when we understand what the English common law thought about allegiance, you can see that you can have allegiance to two different sovereigns at the same time. This kind of goes back to Justice Alito's questions. I mean, I was thinking about this, and I think there are various sources that say this, that you obviously have permanent allegiance based on being born in whatever country you're from. That's what everybody recognizes. But you also have local allegiance when you are on the soil of this other sovereign. And I was thinking, you know, I, a U.S. citizen, am visiting Japan. And what it means is that,
That's not allegiance.
You know, if I steal someone's wallet in Japan, the Japanese authorities can arrest me and prosecute me. It's
That's not allegiance.
Meaning, can they control you as a matter of law?
Oh
I can also rely on them if my wallet is stolen to, you know, under Japanese law, go and prosecute the person who has stolen it. So there's this relationship based on, even though I'm a temporary traveler, I'm just on vacation in Japan.
English is
I'm
such a
still
struggle.
locally owing allegiance in that sense.
Nope.
Is that the right way to think about it?
That's a retarded way to think about it.
Doesn't that explain why both
That's a retarded way to misinterpret allegiance.
Residents and undocumented people would have that kind of quote unquote allegiance just by virtue of being in the United States.
That's absolutely right, Justice Jackson.
If that's
comports with the
if that's what you have to come on to in order to bail this case out for the respondents, if that's what you need to come on to, this is the most retarded take as far as what allegiance is. You know, allegiance means that you're choosing. Oh my God. You're choosing to dedicate your life to something. This is what allegiance is. Not that you're bending the knee to, I have to comply, otherwise I'm going to be in jail. That's what I pledge. Otherwise, what the hell does I pledge allegiance to the flag mean? It's the stupidest thing in the world. What do you understand that to mean? It's aggravating listening to fools basically pretend and cloaked with some aura of having insight and intellect. It's very, very aggravating. Much more, it's so aggravating because I'm like, you're so obviously a moron and you're cloaked with this whole appearance and the world is looking at you, it's like, oh wow, look at this sage individual here. Unbelievable.
Text of the 14th Amendment as it applies to everyone born in the United States other than those subject to the exceptions that were baked in a closed set. You owe natural allegiance as a US born citizen. If you want to look at the parents of those people, and let's say the parents are foreign nationals but not ambassadors, the parents owe temporary allegiance.
Right, so the babies get the permanent allegiance piece of this, and the parents get the local allegiance piece of this. So to the extent we're looking for allegiance, we have it.
That's right.
Thank you.
Thank you, counsel. Rebuttal, General Sauer?
Thank you, Mr. Chief Justice. Justice Kavanaugh, turning to Lynch against Clark that you raised didn't come up when I was talking about. Keep in mind that we say that was questioned at the time. It's questioned by a higher court in the same state, the state of New York.
I don't know.
The Ludlam decision in 1860 specifically said that someone who's traveling or sojourning abroad, though born in a foreign country, is not born in foreign allegiance. So obviously there is tension within that very state, and that's what contemporary commentators noted. And I make a more fundamental point about that. Lynch is not interpreting the 14th Amendment because it predates it. So it's not looking at the language of the 14th Amendment. It's looking at, what does the word citizen mean, for example, in the clause. So there's an anachronism to their reliance on it. And I think that turns to a point that Justice Alito emphasized. Once you get to that language of the 1866 Civil Rights Act, where Congress said not subject to any foreign power, clearly, we are no longer dealing with the British conception of allegiance, because Calvin's case and Blackstone say whether you're subject to another foreign power is irrelevant to whether or not you become a citizen. So again, the concession that I heard to be made that those two mean the same thing, which this court held in General Building Contractors, that the Civil Rights Act has the same scope as the Citizenship Clause of the 14th Amendment. Once you're saying not subject to any foreign power, Congress has clearly departed from the common law, the British conception of allegiance, that monarchical conception of allegiance. They have adopted the Republican conception of allegiance. And there's all kinds of evidence going back to late 1700s that that's the way they thought about it. And there was a reference, I think, in my friend's presentation about the Marshall Woodworth treatise from the late 1890s. That treatise also, just like Lynch against Clark, the language they quote is actually describing the case or the law, the status of the law before the adoption of the 14th Amendment. So, but if you actually look at the treatises we cite again, I mean, Wharton, Morse, Justice Samuel Miller of this court, Lesser, Black, Hall, Winchester, Taylor, Westlake, Ballot, there's this consensus going from the time of the 14th Amendment onward, when they're looking at the specific question of temporarily present individuals in the jurisdiction. All those sources say their children are not citizens. And that goes both before and after Wong Kim Ark. You see a similar consensus actually in the congressional debates, where whenever it comes up, temporary sojourners, it's understood, the context indicates it's clearly understood that those children are not citizens. And I would therefore finish where I began, with drawing a stark contrast and turn back to the first question that Justice Thomas acted. That Republican Congress in 1866 had a very, very clear understanding that the children of the newly freed slaves have the requisite allegiance to the United States. This was all about overruling the grave injustice of Dred Scott and making sure that allegiance was granted to the children of slaves. However, you have this contrast of a very, very strong, impressive consensus, both in the original understanding, in the congressional debates, and carrying over into commentators for 50 years afterwards, that the children of temporary sojourners are not covered. And for those reasons, we ask the court to reverse.
Thank you, counsel.
Very good.
General, the case is submitted.
All right, so there you go. That's a wrap. That is a wrap. I'll tell you right now, gonna weigh in. People ask me like what my thoughts are as to where people are gonna land. And TextVet was asking me where I think ACB is gonna land. I think this case is gonna be 5-4. I think it's gonna be 5-4. I can't tell you the most likely position. I like the way Sauer argued compared. Well, let me break down why I'm coming to these conclusions I'm coming. I think Sauer was a dominant oral arguer compared to the Valley Girl. It wasn't even close. The nature of the questions that we heard from the justices, though, it gives me a great deal of pause. I have a great deal of pause. Just trying to read the room. I have concerns. I do. I have concerns. Gorsuch, I mean, look, the three liberal justices, there's no way in hell they're going to be supporting this CEO. So that means you need to get 5 out of 6 of the remaining ones. Let's assume that Alito and Thomas are in the bag. There was nothing to refute that notion from any of the questions they asked, quite the contrary. Alito in particular seemed very strongly in favor. Gorsuch started off being rough on John Sauer, who was representing Trump. And he came back at the respondents and was a little rough there too. I'm not sure quite as rough, but a little rough there too. It could be though that, and this is something we need to appreciate, it could be that Gorsuch is tougher on John Sauer because he's a veteran of arguing Supreme Court cases and is obviously a lot more confident and knowledgeable. So he's not worried about breaking John Sauer, as opposed to this one. We don't know how she presented herself. And there's just a humanity element to sitting there face to face, where even if he strongly disagrees with her, he might not want her to be crying literally, or, you know, on the outside or the in. So it's really hard to know when we're not there in the room, you know, to gauge how they're asking these questions. All we can hear is their tone and the nature of the questions they ask, like the nature of the questions that Sotomayor asked, where she's saying, here's your argument for you. Do you agree? And the attorney's like, I'm not sure. That was humiliating. That was just embarrassing. But so it could be Gorsuch didn't want to go so hard on her because she definitely seemed like she was like a weak fish who might crack under the stress. That's what you're hoping for. If you want this birthright citizenship to stand up, you need Gorsuch. We need Gorsuch in the bag here. I don't know. Amy Coney Barrett, she seems to get off on the notion of engaging in what she believes to be personally interesting legal philosophical questions. Like, this is the sort of case that I think she really enjoys. And in that sense, I can appreciate that element to her, where she's sitting there and trying to wrap her head around, well, oh, what would you say in this scenario here, and what makes that philosophically different, and the approach of the court in this other case. And she seems to very much enjoy the philosophical principles that are governing both statutes and prior case law, and especially when they seem in tension with each other and trying to come to some sort of solution. So, but that doesn't always play out. That's what she's doing for oral argument, and that doesn't necessarily play out in how she writes her decisions. It's almost like she looks at oral argument as like kind of like a game. That's how I read her questions in general. Her questions are very, very much into like trying to parse out intellectually, in stark contrast with Ketanji Brown Jackson, that she tries finding the tension between one case and another, or how a statute has been interpreted by multiple courts to try and find the law, which is logical. It's an appropriate way for a justice to start off asking the question. I think that she ends off. I think that when it comes time to actually putting her name on one side or the other of a decision, that seems like it's almost pre-scripted. But while we're here, let's have fun. That's basically Amy Coney Barrett. So I don't know that we ever can take much from what she's asking as a read on her, because I think that it's a feint. It's like a trick what she's asking as to like what she's thinking and what her objective from oral argument is versus what her ultimate decision is. That's been my experience with her. So she's a very, very tough read. And again, we need 5 out of 6 of these if we're going to get birthright citizenship. Can't. So Roberts was almost silent. I sensed a little bit that he's on our side here, a little bit, but almost silent. And then you have Gorsuch and Kavanaugh. I don't know. There's some rough moments there. Kavanaugh seems to basically be brown-nosing whoever's up there on the stand. Instead of probing, he seems to be brown-nosing Sauer, and he seems to be brown-nosing a little bit the response attorney. So, which, you know, his resume is that of party guy. You can understand him wanting to be liked. He reminds me a lot, if you're a Harry Potter fan, of that guy from book 4, the one who was like just going around jovially. He was in the book, not in the movie. I forgot his name, but the guy who had been a professional Quidditch player. Where it's just like I want everyone to like me, and you know, I want to be popular. So let me be nice to like everyone and sort of ask a little question here and there. Yeah, this is how I think of John Kavanaugh. Brett Kavanaugh. That's how I think of Kavanaugh. I like beer. So yeah, I don't know. I have grave concerns. I feel like there's too many toss-ups. There's no one who came out of this, aside from the 2 that we knew were in the tank, who I was like, oh yeah, this one's definitely on our side. The closest to that, I think, was perhaps was Chief Justice Roberts, right? But out of those 4 who were deciding every single freaking case, of Gorsuch, Kavanaugh, Barrett, and Roberts, out of those 4, Roberts sounded the most on our side. Gorsuch was irritating the hell out of me. Kavanaugh sounded like a toss-up. And I don't think Amy Coney Barrett really shows her hand. I think that she looks at this as not a way of trying to learn anything. So you think ACB has a presupposed position that she doesn't sway from and uses arguments purely as a game of hypothetics for the sake of forming her worldview, or did I misunderstand? Oh, no, you got me exactly correct. That's the read I have on her. I could be wrong. I don't think that she's using it to decide anything. I think she's like, oh, this is really interesting. So let me, what would you think about this perspective over here with respect to the tension between you solely? And she loves flashing her extensive education. And she is highly educated. And she's not. She's a very smart woman. And like I said, in stark contrast to some of the other justices who are just a walking joke and don't understand anything. So it doesn't mean she's a good justice. It just means she's smart. I think Nancy Pelosi is a very smart politician. It doesn't mean she's a good politician or a good person. So I have concerns. I don't think anyone can tell from this thing as to where it's going to go. I can really see this going either way. There was a couple questions that I was asked during the course of the show that I didn't want. I sort of put aside, and I said I'll come back to later. And this was not even this was just a question I saw. How can SCOTUS override a law that's supposed to follow a law and I'm missing something? They're not overriding a law. They're explaining how what this law means. It's not overriding a law. And this sort of ties into the whole ex post facto ruling that I saw someone mentioned earlier, which is actually 3 words, ex post facto. And it wouldn't be an ex post facto to say, first and foremost, because the government is looking to have it go forward. It wouldn't affect anyone who was born before today or before the decision's issued. Anyone who was born the next week would still be a citizen. They would just be applying it going forward. So there wouldn't be an ex post facto factor here. Donald Lee Thomas asked me, would your contention concerning Charlie that if the bullet cannot be matched to damage would still be a defensive argument? I would like to know. Would it be concerning Charlie if the bullet cannot be matched due to damage would still be a defensive argument? I'd like to know. I think that, just imagine this, okay? Imagine that the only part of the bullet, let's say the bullet explodes on impact when it hits a victim, in this case, Charlie Kirk. Let's say it just explodes. And all you just have is like this splattering of metal. It's unrecognizable what it is. So who's to help? I think it helps neither side. I think neither side's able to use it. Right? Does that mean it came from this gun? Does that mean it didn't come from this gun? When it's inconclusive, that's how I think we should think of it. There are 3 ways when they test out matching a bullet to a gun. There are 3 possible outcomes as far as what the determination can say. It can be identified, meaning, yes, it definitely did come from gun X. It can be excluded, eliminated, which means it definitely did not come from gun X, or it can be inconclusive, which means we just don't know. So just think about this. Like if you're going from a jury and you say, okay, we have no idea if this bullet came from this. So you would think it kind of helps the defense a little bit. But really what it is stripping the prosecution of an opportunity to say this gun that we know has his prints on it fired this bullet, and hence he's definitely guilty. So it's a massive, when they can be identified, it's a massive, it's practically an atom bomb. It's potentially an atom bomb in the hands of the prosecution. And if it's eliminated, well, that can be like a massive win, depending on the scenario, massive win for the defense. When it's inconclusive, I'm like, I don't. And this, a lawyer doesn't know any better than you do. Just picture yourself as a juror. Like, how would you take this information? You're like, okay, so I don't know anything from this bullet. See what I'm saying? How many of them argue for the perspective of actual citizens? Trump's EO is written to protect the rights of existing citizens and not migrants. And you're correct, Amazing Disgrace, but the rule of a judge is not to look at it from citizens. The role of the judge is to try and look at it from, what does the law say? My job is not to write the law, but to sit there and try and interpret what it says based on statute and based on prior court precedents. So the outcome and the policies that are being implemented, we're looking for a good justice to ignore that. And what actual citizens want. It's like, that's not for them to write a law as to what's benefiting actual citizens. Now, all too often, particularly leftist judges, we see them all too happy to write laws that's referred to as judicial legislation. But that's not what their job is supposed to be. That's bad judging. Those are, in my opinion, and really under constitutional principles, that's a very, very bad judge who's engaging in that. So, because now you're assuming more responsibility than you ever were gifted, you ever earned. Goshen said, if military members' children born in foreign U.S. base not granted immediately, how is an anchor baby able to? I don't know. I think they are American citizens automatically. Oh yeah, he did. He definitely did. Biden was a disaster. Yeah. Okay. I think he means argumentatively. Defense could take the position, so you can't prove the bullet matches. Reasonable doubt. Enjoy all the supers today. Thank you. Thank you very much. Yeah, no, I understand that as far as helping to create reasonable doubt, and I would agree that. But it's like, okay, the bullet's been utterly destroyed through the course of going through a body. This bullet looks like a nickel. You don't think it never was a bullet? You know what I'm saying? If you picture it like that, a lot of people like to think of it, particularly in this case, as if like, oh my gosh, the bullet doesn't match. We can't. It's not, first and foremost, it's not that it doesn't match; it's that we can't tell that it matches. And since we can't tell that it matches, but the framing of it is almost as if like, we have a bullet that is 30 millimeters in diameter coming out of a hole that's only 20 millimeters in diameter, which obviously couldn't be fired out of it. That's how they're trying to frame it, which is not true. And as far as reasonable doubt, yeah, the burden of proof is on the prosecution. So if you take away one piece of evidence, then that hurts. It definitely hurts. Especially as it could, it opens up the doorway for reasonable doubt. So and you become much more reliant on the other evidence, which may or may not be successful in convincing 12 people beyond a reasonable doubt. So, all right, I think that's I've covered every. Let me make sure I didn't miss anything in. Did I miss any supers here? Any rents? No, good there. I'll do a quick here. I want to remind you all, I will not be streaming tonight or tomorrow night. I will be back here on Saturday night. It's Jewish holiday of Passover. And Torah tells me I'm not allowed to be online. And since if Torah tells me something, I'm going to follow it to the best of my abilities. So you're not going to see me tonight. You will not see me tomorrow. God willing, I will be back here Saturday evening, probably late, because Saturday Shabbos isn't going to end until like 9 or thereabouts. So 8:39. So I'm not going to have. That's when I first would start looking at show material, do research. So I probably wouldn't start for several hours after that. But I do plan on being back here Saturday night and keep you posted with respect to my schedule going forward for the balance of the Jewish holiday of Passover. Those of you who are recognizing and enjoying the holiday of Passover, I wish you a happy Passover. Those of you who are enjoying and celebrating the holiday Easter, I wish you a happy Easter. And those of you who are heathens and don't recognize God at all, I say, good luck. Sorry. I had to throw that out. I thank you all for joining me. Don't eat the bugs. Take care. Godspeed.